Just like another file.
Lordship, in these cases, Lordship, there are interim orders, Lordship.
Just a moment.
It is not indicated, my lord, in the cause, but there is an order of 12-4 asking for further hearing. So perhaps it's a part-heard matter, my lord.
The notes are there. I'll send
Lordship,
it to that same batch.
one thing is also there, Lordship, we have some urgency because 2 months period is already over. One-man committee has taken shares.
Okay, day after tomorrow. Also the duty represented.
My lord, day after tomorrow, some difficulty on Friday. my lord. Thursday, some
Friday.
difficulty on my part.
Okay.
Friday.
It appears from the elaborate note. Made by His Lordship, Mr. Just within brackets, Mr. Justice Manish Chaudhary. It appears that the matter was substantially heard. Stop.
It was court number 4.
Lordship, it was heard by my.
Court number 4, my lord.
Court number,
4.
Court number 4.
This is Michael is not there.
Yes, Lordship.
He's not there.
My lord, item 4 to item A.
No. Honorable Justice Zoltan, she is not here right now.
Right.
Then I can only say it was heard by another bench, list accordingly. I'm not giving a date.
Lordship, in that case,
Because-
Lordship, Lordship may hear it today, Lordship. Because we have some urgency, Lordship.
Let him list it.
Let the matter be called up, Lordship.
Once another bench has heard it, I think it will be appropriate that the same bench hears it.
Lordship, but since the bench is not here.
Okay, then at 2 o'clock, because then I'd make an inquiry.
Can it be on
2
Friday? my lord?
o'clock.
Let us try on Friday because in fact, my lord, I have yesterday informed my learned friend.
No, it's okay. You have it at 2 o'clock.
Well,
In the
2 o'clock.
meantime, I'll make carrying
My
the
lord,
history.
correct.
The
May I please, Lordship?
availability
Correct.
of honorable justice.
Obliged.
May I please, Lordship? Lordship, on last Thursday, we had filed a writ petition. We expected that petition might have been listed today, but not listed today. The urgency of my matter is that the animal of my farm is under pathetic.
Okay, give it to the court master. We have to make some adjustments, 1 or 2 days. It will
Lordship,
done.
as a last item of the day, if possible.
Today it's not possible. Give it to him, we get it destroyed. What is your prayer? What
Lordship,
are you
my
saying?
prayer is animal of my farm are under pathetic condition, as the district administration of Nalbari put the main entrance of the animal farm under lock and key for last 1 month. I have made repeated requests. So Lordship, last item if possible today, Lordship. Last item if time permits. Already writ petition has been numbered.
Okay, have it.
Last item,
Okay.
Lordship.
We'll see because today is a long list.
If time permits, Lordship. Otherwise, matter will be taken up tomorrow.
Okay.
Obliged, Lordship.
Wait, give the Lordship, I beg to list one WPC 69.
Just a moment. Yes.
May kindly be listed for motion matter. It is
Give to the court master. He'll have to make some adjustments, 1 or 2 days. He'll do it.
instead of or motion matter. It is listed.
Which item?
Item 59.
59.
My lord. It is new matter. My lord.
Okay, if it comes, we'll take it up. Don't worry.
Okay.
59.
Ma'am.
59 is a contempt case. It will not come in motion. You think contempt matters come in motion?
Motion. Motion.
Okay, we'll take it up. Don't worry. Yes,
His Lordship, I beg to list one WPC 6982.
give all the praise to the court master. I just told you. He'll have to make some adjustments 1 or 2 days, he'll do it. Please give it to the court master.
May I please your lordships? I am paying for listing the matter.
Please give it to the court master. I am not entertaining.
Lordship, I am quite.
I'm sorry, I'm not
One
entertaining.
submission, on last week, Lordship, Monday, I approached the court. Our court, I directed me to approve the registry. Registry passed an order to list the matter on Friday. In spite of that, it has not been listed. Therefore, urgency is necessary because and
give
the
it to the court
notice has been
master.
passed on day after tomorrow, Lordship. Otherwise,
Give it
my
to the
case has
court
become
master.
impactual.
Please give it to the court master.
Yes, Lordships, obliged.
May I please your lordship? Lordship, I beg to mention item number 65, lordship, with consent of the other side. Counsel for the respondent is out of station.
65. Your phone?
For the respondent, lordship.
No, it's a motion matter.
Central.
At motion matter, in the
Serious.
instance of respondent, I'm not adjourning.
Lordship, Mr. B Chakravarti is out of station, lordship. It may be taken day after tomorrow, lordship. Consent has been taken.
Okay, it is submitted by Miss
A Lala.
A. Lalan, counsel for the petitioner. Sorry, for the respondent that she's making a prayer for adjournment on with consent of the other side. Whose prayer is allowed, list on day after tomorrow. Okay.
Highly obliged, lordship.
Yes,
I beg to mention one matter for listing on tomorrow,
please give it to the court master. I'm not entertaining. Please give it to the court master.
because auction sale.
I'm not understanding, whatever be there. Give it to the court master. He'll have to make some adjustments 1 or 2 days. Because every day in this bench, there's a long list. So he'll have to make some adjustments.
Difficulty is that on 24th, the auction sale is scheduled to be held.
24th.
Yes, sir.
Okay then. Okay, allowed.
Tomorrow.
Yes,
Daily list item number 1, delivery of orders.
in this case, the repetition is dismissed. Sorry, repetition is allowed. In this case, the repetition is allowed. I have given the reasons. I have accepted the submissions of the learned CGC to the effect that the CPW signature will be a necessary party. Secondly, I have arrived at a. You're hearing me? You're getting my voice? You're getting my voice?
Yes, now I'm ready.
Okay. This CPW signature is held to be a necessary party, number 1. Number 2 is that the exhibit numbers 1 to 5 would be inadmissible as the certificates were not, the authors of those certificates were not examined. So this grounds the repetition stands allowed. The matter is remanded back. Mr. Dasgupta, matter is remanded back for a fresh decision.
Item number 2, motion be.
May I please, your lordship?
Yes,
Healthcare was called for your lordship.
this is available. Yes,
Lordship, in this case, lordship was pleased to reject my bail petition, your lordship.
yes.
There is in case number, relevant portion is in.
You were arrested when? What is the date of your arrest?
21/10/2022, your lordship.
21/10/2022.
To 213 days, your lordship, as on today.
On that ground alone, we'll grant the bail because this is otherwise what you call, whatever has happened are matters of record only.
My lord, yes. Here, my lord, the Here in this case, all the accused are granted bail by this honorable court. Only this person has been left, my
So
lord.
that's why,
So, my lord, yes, length of detention, there are contention is length of detention and medical ground of his murder, my lord. That case record has been come, my lord. I have seen here, my lord, the cognizance has been taken. Charges not framed yet, my lord, and the next date is fixed for appearance. And all the vehicles numbers has come. That it shows, my lord, some vehicles are not hired and forced. That much.
okay,
Lot.
S. A. Hussain, your lordship. S. A. Hussain, your lordship.
S.A. Hussain, heard Mr. S.A. Hussain and counsel for the petitioner. And Mr. M. Fugan, PP, appearing for the state. Next one. The petitioner was arrested on 21/10/2022 and has spent 3 days in custody. Has paid for regular bail under section 439 IPC. Sorry, in connection with vigilance PS case number 4 of 2022. This one, sir. Next one. The case records was called for, case record which was available in BA 36 of 2023 and BA 1565 of 2023 were called for. So the learned public prosecutor has perused the same and has opposed the prayer for bail on the ground that the investigation carried out so far reveals that by providing fake registration number of vehicles, an exorbitant amount was siphoned away from the Guwahati Municipal Corporation in connection with desilting works of drain in Guwahati city. First off, it is submitted that fabricated weighbridge slips were also manufactured for the purpose. First off, it is further submitted that this racket involves a large number of personnel. And the petition is expressed that if the petitioner is released on bail, he may influence the trial. Next para. It is seen that this is the third application.
Second.
Second, your lordship.
There is a second bail application in respect to the petitioner. First one, the case records reveal that charge sheet has been submitted on which date?
11/1/23 and cognizance was taken on 12/1/23.
And cognizance of 12/1/2023, and the trial has not yet begun. First one. In this second application for bail, the petitioner has taken a plea that his mother is unwell.
Mine.
And she's suffering from
Page 11, para 13, your lordship.
orthopedic issues relating to joint of knee. First one. Although the case records reveal sufficient incriminating materials against the petitioner of conniving with others and submitted bills with fabricated records, with fake and fabricated records. First one, nonetheless, as the petitioner has spent 2 and 3 days in custody, and the offense and the nature of offense is recorded in the form of records the court is of the constitutional opinion that as charge sheet has already been submitted, further custody interrogation of the petitioner may not be necessary. Hence, considering the length of detention, the court is inclined to release the petitioner, namely Dinesh Jaiswal, on bail in connection with so and so, on providing a bail bond of rupees 1 lakh with two solvent sureties of like amount to the satisfaction of the learned special judge,
My lord, special judge,
Kamru Metro Guwahati.
my lord.
Special.
Or it will be special judge Assam. What is it? This is special judge Assam.
Assam, lord.
Special judge Assam. Guwahati. Bail is granted on the following conditions. We give that he shall appear on each and every date of trial and shall not dispute the identity. In the event any conditions of the bail is violated, and if the petition defaults in appearing before the learned trial court, it would be open to the learned special judge Assam to cancel bail and secure the petitioner for expeditious trial. The records of BA 36 of 2023 and B 1565 of 2023 are be tagged. Yes,
Much
you
obliged.
wanted to say something?
My lord. Here, my lord, written as my special PP Assam, my lord. In this case, my lord.
Achha, his status will be special PB Assam.
Much obliged.
Item number 3 for motion.
Yes,
May I please as a lordship? Lord, the orders have already been passed, my lord. The issue is there. So the petitioner before my lordship is a Muslim marriage registrar, my lord, under the, my lord, provision of the Act of 1935. Now, my lord, by virtue of my license provided to me, my lord, I am entrusted with the duty of registering the Muslim marriages.
Mr. Mazumdar,
My lord.
you have seen the Muslim Marriage Act. You have seen the provision. It permits minor to be married. What can be done? You will have to amend it. You use your what you call prerogative of giving advice to the government. Once that provision is there, you can't be. What is that 32?
My lord. 1935 Act, my lord.
No, what is that provision of marrying a
Provision
minor?
is Rule 24, my lord.
24. Huh?
My lord.
It says that in case of marriage of a minor,
My lord.
then consent of the guardian is to be taken. Unless you amend it, this mischief will happen.
There are more.
Assam Muslim Marriage Registration.
My lord.
Section 42A of Oxford or something like this.
No, you see, when there is a conflict, this is a special act. Also-
Says, section 42A says,
So what happens when it's a conflict? Then the interpretation which is favorable to the accused will be have to be accepted.
there is no, when it says, even if it's inconsistent, this will have overriding effect.
Oxford, no? You see, I'll tell you why. Number one, the special act, just give that Assam Muslim Marriage Registration Act. Major acts. M. You have that book?
No.
Page 50, my lord, may be please.
Page
50, my lord.
50.
My lord.
Now, Mr. Mazumdar,
My lord.
you see, for the Central Act
My lord.
to have an overriding effect over the state law, the consent of the state has to be taken.
Correct.
But if that is not done, Central Act, although it has an overriding effect, can it make OTOs the provisions?
Lord, section 9 is relevant, my lord, and rule 24.
No, not that, not 24.
My lord.
That he'll have to take consent of the,
My lord.
One second. He'll have to take consent. In case the girl is a minor.
Consent of the guardian, my lord.
Yes,
That part, my lord, at page 73, rule 26, my lord.
26.
My lord. Page,
Ah.
page 73.
26, procedure before registration. The Muslim registrar shall certify into whether or not a marriage was effected by the person by whom its representative have been affected in the following manner by examining parties to the marriage, or if or other, both of them are minor, they are lawful guardians. So therefore, if a central law will eclipse this, this procedure will have to be followed, because then the Central Act will say that this rule will not prevail.
It's 1935, it is Assam Act.
Assam Act and the rules. This is Assam rules.
Assam, yes.
So the state will have to withdraw it in view of the 42A. The state will have to come up with an amendment.
Well, 42A also reads like this: provisions of this act shall be in addition to and not in derogation of the provisions of any other law for the time being in force, and in case of any inconsistency, the provisions of this act shall have overriding effect on the provisions of any such law to the extent of the inconsistency.
Because that will have effect on only the central laws. The state laws will not be overruled by that. Unless you can show me any decision of the Supreme Court where that
One-
proposition has been accepted.
One judgment of the High Court is there, this issue came up. Kerala High Court judgment, my lord. In para 80, it says it's a judgment of 2022. The aforesaid section categorically asserts that in the event of any inconsistency with the provisions of any other law, the POXO Act will prevail. Personal laws and customary laws are both laws. Section 42A intends to override such laws also. Therefore, it cannot be gainsaid that after coming to force of the POXO Act, penetrative sexual intercourse in a child, even if it is under the guise of marriage, is an offense.
No, he is a Kazi.
No matter he
My lord,
is
I am a
Qazi,
Muslim
he
marriage
has- he
registrar.
will come within the meaning of abatement of office, because he has not only this, his statement was recorded, there was an inquiry was conducted. His, on the last document, and the statement was produced. His statement shows that he has admitted that it was a mistake on my part, that he has not only registered, but also he has performed the marriage as a Qazi, because he is not only MMR, he is MMR and Qazi. So as a Qazi under the 1880 Act, he can in fact perform it. So he has performed. So he has admitted in his statement what he can.
But the rule says it permits. Minor is specifically permitted under the Mohammedan law. This citation you are giving is, please give the citation there.
There is my lord, your lord will get it in 2022 0 Supreme Kerala 818.
Just a moment.
Or your lordship may find out by this name.
Um, 2022.
2022 0 Supreme. This was the issue in that case, madam, when it is permitted under the their Sharia
This is a which state? Kerala.
Kerala.
a minor girl from West Bengal was kidnapped and he said he has married. Thereafter, this case came up.
Page, please give me the page again.
Page, my lord, 819. 2022 0 Supreme Kerala, page 819. Khaledur Rahman versus State of Kerala.
Even if I read this, here they are dealing with two acts.
Right.
One is Prohibition of Child Marriage Act,
Right.
and the other is Muslim Personal Law Shariat Application Act of
Right.
1937.
Right.
Can you tell us whether these are central acts or it's a state act?
My lord, paragraph 10 Muslim Personal Law Shariat Application of 1937 statutorily recognizes that in all questions relating to marriage, the rule of decision shall be the Muslim Personal Law Sharia.
But there's a central act.
My lord.
So central act, I can understand the government have all pervasive.
Then the question of this special law and this, my lord, general law was also taken into consideration in paragraph 13, Lord, you can say. However, the petitioner is arrested for the offense of censorship. Para 13 and 14, my lord.
13, 14.
However, para 13, I am reading, my lord.
Yes.
The petitioner, however, the petitioner is arrested for the offense under POCSO Act as well as the IPC. The POCSO Act is a special statute enacted specially for the protection of children from sexual offenses. Sexual exploitation of every nature against a child is treated as an offense. Marriage is not excluded from the sweep of the statute. In this context, it is relevant to refer to the legal maxim. Generally, a special is non-derogant. A special law will prevail over the general law, and specially generally this derogant special things derogate from the general things. The said legal principle has been deployed for resolving conflicts between two different acts. Refers to the decisions in JK Cotton Spinning and Weaving Mills Company Limited versus State of UP and others. AI 61 Supreme Court 170 and 2002 5 SSC 5 will be opposite. In the matter of the above decision, it was observed that when the courts are confronted with such a situation, the court's approach should be to find out which of the two apparently conflicting provisions is more general and which is more specific, and to constitute the more general one as to exclude the more specific. Further, it is strike law that when the provisions, I'm just pausing for a moment. I'm just the question here is not the question of existence of general law, special law with regard to the marriage. General law, special law with regard to the offense. There is two things.
You see, if one is performing, I can understand about the husband,
right,
or the family members. But when there's a Qazi and he has been bestowed with this power under the state act and rules,
Yes,
whether that can be,
that I have seen, I know that. But what I'm saying is, my lord, after this Child Marriage Prohibition Act has come into force, after the POCSO has come into force, now the question will be when a particular specific law provides, when this principle, the doctrine of general and special law will come to the aid of the my lord, the investigating agency, rather, to say that there is a special law providing for offense if a person does that. I'm just reading my further. Paragraph 15. Further, it is strike law that when the provisions of a statute are repugnant to or contrary to the customary law or personal law, in the absence of any specific exclusion of the said customary personal law from the statutory provisions, the statute will prevail and the personal law or the customary law shall stand abrogated to the extent of its inconsistency. On an appreciation of the above principles, it can primarily be held for the purpose of this bail application that the very marriage allegedly entered into between the petitioner and the victim cannot be relied upon as a legally valid marriage. As mentioned earlier, the POCSO Act is a special enactment. The advances and progress achieved in societal thinking have resulted in the enactment.
This special statute was enacted based on principles arising out of jurisprudence relating to child abuse. The child abuse jurisprudence evolved out of the need to protect the vulnerable, the gullible, and the innocent child. The legislative intent to protect the child from sexual predators hovering over them under different levels, including that of marriage, is explicitly evident from the statutory provisions. Child marriages have been regarded as a human right violation. A child marriage compromises the growth of the child to her full potential. It is a bane of society. The legislative intent reflected through the POCSO Act is to prohibit physical relationships with a child. Even under the cover of marriage, this is the intent of society too. For a statute is, as is often said, the expression or reflection of the will of the people. In accomplishment of the said intent, the POCSO Act has defined the word child in section 2D as any person below the age of 18 years.
Just a moment, I'm stopping you for a moment. You see, according to you, what is abatement? What would be abatement? It is defined whatever is in the IPC, right?
And
Now-
also in the POCSO.
Yes. Now. Now you see. Same thing again, it is a repetition of my question. If you have this POCSO Act, please look at the statement of objects.
Yes.
Statement of objects and reasons. Article 15 of the Constitution confers upon the state to special power for children.
Right.
Article 13 entirely provides the state that in particular directs its policy towards securing the tender age so and so.
Right.
Correct.
Right.
Here it says everything, but they don't touch the word marriage here. Marriage word is not touched here.
Marriage word possibly is not touched in the POCSO.
Yes. Now second thing is,
Right.
the only concern is if the state enacts a law which is prevailing and it has not been repealed, either in the text of this POCSO Act
Right.
or by implication. A Qazi who is performing his duty as per the Muslim this marriage rules.
Right.
Now, can it come within the meaning of abatement? That is one. And number two, if the state maintains that law without repealing it, whether the state itself is guilty of abatement, because you have a law which permits it. Somebody does it, then you catch him.
But it doesn't really permit if you look, actually goes to the exact words of the section, my lord.
Because now it is a judicial interpretation, and the Kerala High Court never interpreted the effect of repugnancies when it comes to the state law and the central law.
That
Here
state-
we have
state
something.
law issue was not there.
We have something here. You take a call.
Right.
We'll take it up next week. In the meantime,
Let me do some more.
if you can give a good advice somewhere where it is required, I think maybe things will change.
As far as the issue of marriage is concerned, possibly one case has gone to the Supreme Court. Notice has been issued. right?
No, but still this issue will never be there, where a Qazi is permitted to do it.
No, I'm not saying that because of that we will wait. I'm simply saying that as far as.
Because you
marriage is
see,
concerned-
that is why for that purpose only,
Right.
when I was granting bail in POCSO matters involving child marriages, I always, in context of Qazi, I use this provision. I say that it is permitted and therefore I am granting. But the state never took it up. The reason for giving that section is only that, because this is something which after
I've
that
read
argument, was advanced, I tried to see many pros and cons, how to deal with the issue.
And it was an act of 1935.
Pre-constitution, it is otherwise saved under 372. So I did my homework then, but doing homework alone is very difficult.
Two heads are always better than one.
Since now I have the advantage of additional education, it is easy to
All right, next
can
week,
understand.
Lordship, fix it Wednesday next month, Monday, Tuesday.
Wednesday next. So in the meantime, if you give an advice, I think that only will clarify. Otherwise, this menace which you are trying to stop In this,
Conflict is there.
in this, you see, statement on objects and reasons. Their marriage is not there. Therefore, when I,
Marriage is not there, we cannot straightway say it may come indirect marriage. I'll just.
no, that's what I'm, let me clear my mind. You see, number one, when marriage itself is not the subject matter of the statement on object of POXO, then whether by a judicial interpretation, we can import certain things which are not otherwise available either in the act nor in the statement of reasons on objects. But there again, the intention of the legislative intention has to be seen. Once that intention to touch the Qazi for the marriage,
I'll have to go through the provisions of this Act of 2012, but possibly marriage also will come.
it's okay. That's the interpretation. If that marriage is somehow covered within this,
Marriage will be covered, definitely. I'll make myself. Let's be taken up next week, Wednesday.
so then also
My lord,
the state will have to give an instruction to all their MMRs and Qazis
my lord, possibly.
that
spite of that.
this will override, because you see, governmental instructions not being there. If I'm performing the act as the rules provide, perhaps abatement will be will be for all other Maulvis who are not MMRs. Perhaps for them it will be attracted, because then they are not performing their duty either as in terms of the Sharia, nor in terms of the Muslim Marriage and Registration Act. So I think the government can clarify with a OM or something. That also can possibly from.
My lordship is well aware, my lord, the Punjab and Haryana High Court has recently passed a judgment holding that as per the Sharia law and as per the Muslim personal law, the age is 15 years of a girl. Now, my lord, that judgment has been challenged before the Honorable Apex Court. And Apex Court is.
No, you see, for that I have my reservations. I have my own reasons to have a different view. I have my own reasons.
The Kerala High Court, which my learned senior friend has relied on, my lord.
No, that will have overriding effect. You see, because of the fact that India is a signatory to the United Nations Convention of Right of Child's Act, that declaration. That you will find in the statements of objects.
Yes, yes.
Here on 11th of December 92, the government of India accepted it. Once that is accepted, then it's a tacit approval that the government will frame a law, and therefore this law, POXO Act, its validity, I have my own reservations whether it can be challenged or not. The reason is that there are Supreme Court not less than 3 judgments where, because of the UN resolutions which have been adopted, that will prevail over any other laws, and there's a direction that even for that green tribunal and that those things, those were arguments were imported, and it was accepted that once there's a United Nations charter which has been accepted by the country, a law will have to be mended in that manner.
That will have an overriding effect on the personal laws.
It will have. It will have, because once the government is a signatory to that and forms a law, therefore, if the Advocate General gives a proper advice and the government acts on it,
one more
so that can be interfered.
One more aspect is there, possibly in section 8 of this 1935 Act. It speaks about registration only, not the marriage. If the marriage is permitted, then he will register. If the marriage itself is not permitted, he will not register.
Then you know how to go about it. You are absolutely right. You are absolutely right.
It only speaks about registration. It doesn't speak about the marriage. Now, if the marriage is illegal, naturally he will not register.
But the rules permit that. It gives a prescription. That is the main difficulty.
No, rules cannot go beyond what is there provided in the main
No,
Act.
you can interpret it.
Anyway, let me come.
Your interpretation is always welcome.
My lord.
Because if something you want to save, then typically the doctrinal repugnancy will have to be addressed by the court. But Mr. Ayar here on counsel for the petitioner. Assam. Sorry. uh, I'll just frame that question. So easier, whoever deals with it later on. The learned additional advocate general has submitted that in view of the provisions of section 42A of the POXO Act, 2012, the conduct of marriage conduct and registration of marriage by a Qazi under the Assam
Muslim marriages and divorce.
the
Assam Muslim Marriages and Divorce Registration Act 1935.
Assam Muslim Marriages and Divorce Registration Act
1935.
1935 and rules and rules thereunder, framed thereunder.
Lordship, and make a reference of
Just a second,
2006 Act.
42A will have overriding effect of the Muslim marriages and institution. Yes,
This 2006 Act also will have to be mentioned. Some
which 2006 Act?
Prohibition of Child Marriage Act 2006.
Acha. It is submitted that in a recent judgment of the Kerala High Court in the matter of Khalidur, Khaledur Rahman, Rahman versus State of Kerala, BA 8216/2022, decided on 18/11/2022, and reported in within bracket 2022 bracket closed 0 Supreme within bracket Kerala KER bracket close 819. An elaborate discussion has been made in the issue of marriages performed under the personal laws, and it has been held that marriages made in respect of a minor Mohammedan girl cannot be saved, and the prosecution and the concerned parties who have conducted the marriage or have married or participated in the marriage could all be prosecuted under the POXO Act. Next paragraph. It appears from the provision of Rule 26 within bracket 1 of the Assam Muslim Marriages and Divorce Registration Rules from 1935 that the duty prescribed for a Muslim registrar is that before registering a marriage, he is required to examine the parties to a marriage, if either or both of them are minor, their lawful guardians, full stop. Therefore, insofar as the Muslim marriage registrar and Qazi is concerned, the court finds that if he exercises power in accordance with order with Rule 26 within bracket 1 of the said 1935 rules, is same being within the prescription of law. Or the question would arise as to whether Qazi could be held liable for abatement. First off, a second issue which arises in this matter would be that in light of prescription of the Assam Muslim Marriages and Divorce Registration Act, 1935 and rules framed thereunder, whether without declaring the state law to have been expressly overruled or overridden by the POXO Act 2012. Whether if there can be deemed repugnancy of the state laws. Mr. Majumdar, I'm framing it correctly? Stop. Next paragraph. Therefore, on the next date, the Honorable Additional Advocate General.
Well, another issue may come from the provisions of the Prohibition of Child Marriage Act 2006. It's a penal
Okay.
under section 9 and 10 of the act.
Okay. It is another question may arise in this matter as to whether in view of section 6 of the prohibition of
Child marriage.
9 and 10, madam.
section 9 and 10
9 and
of
10 of the Prohibition
Prohibition
of
of
Child Marriage Act 2006.
2006, the
Yes.
same would prevail over the 1935 Assam Act and rules framed thereunder. Correct?
Well, one more question which I
Yes, yes.
subsequently make. Whether this section 8 of the
Assam Act.
Assam Act
Yes.
will also include the action of the marriage, because it only speaks about registration.
No, you see, let us take a proposition. Supposing the marriage is illegal. Let us say that there is a marriage between a Sapinda. Correct. That is illegal under the Hindu Marriage Act. Now, if a marriage is otherwise illegal, it can't be registered. If despite that it is registered, then you'll have to take action against the registrar. Supposing you are arguing, sitting here and arguing, and today I am approaching the registrar of the registrar of documents, saying that Mr. Majumdar has sold me his land, and without your presence, he registers the sale deed. Then what happens? He's done an illegal act. So he can't be saved when the sale deed is registered in your absence. If in your presence it is registered, then perhaps he will not be officially liable because he will be saved by that official act. But if it does it in your absence, without recognizing your signature, without knowing it, without your presence, then whether the sub-registrar, he can't be proceeded with. Illegal act is ab initio, whether it is registered or not. The registration will not save it.
My subject is slightly different. What I am trying to say is, madam, section 8 doesn't per se speak about the validity of marriage or the permissibility of child marriage. It speaks about registration. Now, if there is any question of invalidity of the marriage, it is because of some other act, not this act. This is what I'm saying. If the marriage is otherwise prohibited, this act was passed in 1935 when this POXO and this child.
This again is a central law. Again the same problem will arise. It's a central law.
Let the question be there, is what I'm saying.
Okay. Yes, you find that sentence, you say that whether they can be deemed repugnancy of the state act and rules. in light of the prescription of section 8 and 9 of the
Prohibition of
Prohibition of
Act,
Child Marriage Act.
6.
Next, but I was agreed to by both sides. This term, next Wednesday, give it
Right.
31,
Right.
31/5.
Lord, there is an interim protection. my lord, that-
Okay, interim process. To the petitioner by order dated.
my lord, on the very first date, my lord.
No, first day notice was issued.
No, till date, my lord, no notice has been issued in this case. First
Notice
day-
has not been issued.
No, my lord.
Then I have to issue notice. Just
My
wait.
lord, my lord.
Otherwise, I can't frame that question and start hearing.
My lord.
No, there is no interim order.
My lord, no coercive action has been directed to be taken on the very first day, my lord. Lord, there is an order, my lord. Last line of the.
Oh, acha.
my lord.
The interim production by order dated 23/2023 stand extended till the next date of listing.
My lord.
Okay, just before that,
Lordship issue notice.
it is in the second sentence. It appears that the matter has been listed on quite a few occasions. So however, notice of motion was not issued. So accordingly, the court is inclined to issue notice of motion returnable forthwith without requiring the petitioners to take fresh steps. Mr. Howard, you want extra copies?
My lord.
Howard, extra copies of the writ petition be served on Mrs. S. Sharma, learned government advocate assisting the learned advocate, additional advocate general. While adding appearance of Mr. Mazumdar, you add Ms. Sharma's name. Okay.
Applies, my lord.
Item number 9. 9.
Made feasible.
Yes.
Please. The petitioners.
I don't mean to mind. I think we pass over for the time being, man. We send people eyes on legs. For time being. Right.
Yes.
Please, Your Lordship, my lord, item numbers 10, 11, 12, these are connected matters. Can it be passed over for time being, my lord? The senior is on next. Okay, on the next. I'm obliged.
13.
Yes. 13.
13.
Still registered contractor under water resource department.
Outstanding bill.
Yes,
I'm
Lord.
sure notice.
Notice first. 17, 17, 18.
What is the date of your work?
The work consolidated statement, my lord, in page number 12, my lord. Stating that date 15/11/13, my lord. Bill says, work order was 22/2/2012. my lord.
But as per that, Thamshan, it would be barred by limitation.
Well,
An executive engineer is also not competent authority.
liability statement given by the 28/11/2022. my lord.
You see that liberation that it doesn't extend limitation. You are aware of either section 25 of the Contract Act or section 18 of the Limitation Act. you have to demonstrate because the term sheet says that if it is barred by limitation, that it can't be entertained.
The communication was going on 28/11.
Mr. Jain, that doesn't extend communication, that communications do not extend limitation. You be prepared at 2 o'clock, you take it up. On question of limitation, you consider that judgment of Tamshar Ali. The question of limitation, 3 years, if it is raised after 3 years, when the matter is barred by limitation for a civil suit, there is a direction that
Work order, my lord, issued on that day. Work was done and the bill raised. Then, my lord, the payment was not made, my lord. Then, my lord, on 28/11/22, the liability statement has been given by the.
is it acknowledgement within the meaning of Article 19? It is not. Because every acknowledgement has to be made before expiry of limitation.
Since, my lord, the work has been done, the process of non-payment was counted from the date of issuing of the liability statement from the concerned department. The executive engineer who has issued the liability statement, he accepted the liability.
You finish the work when? What is the date of finishing of the work? Bill was raised when? Give the date of the bill.
He was raised on 15/11/13, my lord. But the fund, due to non-availability of fund, my lord, the payment was delayed. That was the issue. I have done my work has been completed, my lord. I have done the work by taking loan from my friends, etc. But after executing the work, I have not received the money from the concerned department. At this stage, my lord, issue notice maybe, my lord.
No. It will be dismissed. That's why I'm giving you time till 2 o'clock to make that address. If you're not making it, then I am taking it up.
Then I have to take instructions from my client, my lord.
That's why I was giving you time, but you have insisted for a hearing. Yes, you see, AR 1964, Supreme Court 1006, State of Madhya Pradesh versus Bhailal Bhai. Here in para 21, the Supreme Court has said that although provisions of limitation act do not apply proceedings under Article 226, the period of limitation prescribed by Limitation Act for instituting a civil action may ordinarily be taken in as a reasonable standard by which delay in seeking remedy under Article 226 can be measured. Yes, what do you say on that?
Since my lord, the communication was going on.
No, whether it can extend limitation, that's what you have to answer. Communication between you and the officers, whether it will extend the period of limitation.
My lord, the fund has not been due to the bill are laying in this division due to non-receipt of fund from the government till date. My lord. So since the fund was not available, the payment was not done by the concerned department. In page number 11, my lord, they have clearly stated, my lord.
Yes,
I need to take instructions. I need to take instructions.
we take instructions. Okay. Mr. D.K. Jain and counsel for the petitioner, and Miss
Jay Google.
J. Gogol and standing counsel for the Water Resource Department, appearing for the respondents, and Miss N. Burman and government advocate appearing for respondent number 1. Hmm?
Only one.
Only 1, 2 and 3 by. Sorry, 2, 3, 4 and 5. Next one. The based on the liability statement dated 28/11/2022, issued by the executive engineer, Guwahati East WR Division, disclosing an amount of rupees 4,44,160 due to the petitioner. This petition has been filed for direction of the respondent authorities to make payment of the said dues. Issue notice returnable on so. Requisite extra copies of the writ petition which serve as the state and departmental counsel in course of the day. Next, the pendency of this writ petition shall not be a bar for the respondent authorities to release the payment due to the petitioner.
Item 19 is also same.
Item 19.
19 also same. Okay. Okay. Here the amount will be different. Yes, 14.
Here in Lahua forest area, which was declared, it was not earlier my lord forest area, it was
added to Tiger project of late. And there were 13 schools, my lord, primary school, provincial schools, they have been evicted.
Will issue a notice at this place.
My lord,
No, let him get
I
instruction.
have instructions. my lord. And this case, my lord will go to page 9 of the petition, my lord. And government has, by the decision, my lord, 25th April, this school has been merged, my lord. My lord, kindly see, my lord. Para 7, my lord, page 9, there's a list of schools, excluding one is a madrasa, my lord. My lord will find mention of the schools, my lord, have been merged with these other schools, my lord.
Okay. You give him a copy.
Yes, I'm giving it.
I'll
I'm giving
still
right
issue a
away, right?
notice.
I'm giving right away, my lord.
I'll still issue a notice.
Notice no issue, my lord, let
On
them,
the next
it is
day,
not dead, my lord.
on the
let
next
them-
day, if this is correct, then we close the writ petition.
No, what I want, my lord, what they should bring the instruction in detail is, what is the distance from the earlier school to the present school where it is merged?
No,
Okay.
it may be anything, but that has to be challenged, not in this writ petition.
My lord?
That can't be challenged in this writ petition unless you amend it.
No, no need of amendment, my lord. Merger, we accept. But whether you
No,
have merger is, my
that-
lord,
no,
10
no,
kilometers.
that challenge itself is not here.
my lord,
Your,
no.
your prayer here is to open the schools,
Yes.
and the schools are opened.
Now, one thing you have to highly, human problem. Children are 6 to 14 age under the RTA Act.
No, you
And
see,
my lord, if the school, suppose it is here. if it is
Mr.
mar-
Sharma,
if it
Mr.
merged
Sharma,
with-
I'll be bound by the prayers made in the writ petition. I can't go beyond your prayer. In your prayer, the prayer is that the schools should be opened.
Yes,
Government is now here with a policy decision that the schools have been merged and they are open. So your writ petition, nothing survives.
it will survive, my lord, I will come. Let me argue. But if the schools are merged with, suppose school is here. And if it is merged with 3 kilometers or 4 kilometers away. Then these children in the forest area and flood ridden area, walk that problem whether they have done
Mr.
it,
Mr.
whether they
Sharma,
have considered or not.
Mr. Sharma, as being a man of public routes, you have gone to villages, right? When I go to a village and somebody tells me, I ask the address of, say, Mr. Sharma, he will say, there, that far. That means from the tone of that far, I'll have to understand it is 1 kilometer, 2 kilometers, or 5 kilometers away.
No, if your lordship goes to missing area.
No, whatever be,
No,
But
and one
the-
thing, I have been to Majuli and other places. If you ask, Amukar Ghar ki Mandu, right to sir, yate ase. You walk and walk, it is nearly 8 kilometers.
but that's what I am saying. From
And
the tone,
also the Nepali people.
the tone of there, you'll have to understand, even in Shillong, when they say Utu, you'll have to understand what is that.
No, let us be practical, my lord. Let them get the instruction. What is the distance between the present school?
No, that I'm not asked. You'll have to amend your petition. If you make that prayer, then it is okay.
No,
But
I
in this
can
prayer,
amend my lord only if they bring the details.
no.
Yes,
I'll
my
not
lord. Otherwise,
I'll not
blindly,
get
how
that
can I do it,
information.
my lord?
I'll not get that.
No, my lord, when I can challenge, when they bring the matter to court or to my information, that this should be merged in 3 kilometers, 5 kilometers, 10 kilometers, then I can challenge that.
No, the
I
petitioner would
cannot
know.
challenge anything on here, my lord.
The petitioner would know. If they have a public interest, they will know.
My lord,
If they have any public interest in intention with them, they will know where these schools are.
no, we will get the instruction. But let them also get it. It is welfare issue, my lord. Simply what they say, it is not.
Mr. Sharma,
And
then
interest was
I can
there.
tell you, then it will lead to dismissal. I'll tell you why. Number one, the area where the schools were located was a forest area.
Then it was not.
No, I'm not.
Then it was not.
When?
When the schools is established.
Oh, that I don't know. You
Yes,
see,
website is the restriction.
once a land is declared to be a forest area, then we don't go to the antecedents of that land. Now the question would be, supposing, let us say, for example, within the periphery of the, any national, any forest reserve or anywhere, a school is established.
Yes.
Now that is the core of the forest. Let us say it is a core of the forest. And the periphery of that forest would be 10 kilometers. Correct. I'm just giving an example. It may be inappropriate, but it's an example. The school where it was located, the periphery area would be 10 kilometers. So any school which will be relocated has to be 10 kilometers away, whether you like it or not.
My lord, recent the Supreme Court judgment has come mallet whether than case. Even in establishment of industry, heavy industry, oil mining, oil digging. My lord, it is my, because I am doing 2 or 3 cases from Silchar, my lord. It is now come down to, because the government of India approached the Supreme Court to amend the earlier judgment and orders that if this is to be enforced, then there cannot be an industry. Already established industries are running. On the in that basis, it is 1 kilometer now. I bring the judgment. Let them also get instead, let them also fair, mal, I will also fair.
No, that instruction I won't get.
My lord,
That instructions I won't get because it's beyond your prayer.
no, my lord, you are also telling me to challenge. I can challenge my lord only if I get the purpose.
No, this is not an information commission where I'll get information and give it to
No,
you.
no, it is the instruction I am telling, not
Instructions are there. He has given that instruction. That
And
is
out of
good
30
enough.
mal, only 10 schools have been sold. What about the 3 others?
That's why I'm issuing a notice. You'll get the information for others.
Yes.
Heard Mr. R.P. Sharma, Learned Counsel, Senior Counsel, assisted by Mr.
M. Rahman.
M. Rahman, Counsel for the petitioners. And Mr. D. Gogoi, Learned,
I'm for 5 and 6, madam, Forest Department,
Learned Standing Counsel for the Forest Department, representing
5 and 6.
respondent numbers 5 and 6, and Ms. M. Burman, Learned Government Advocate, appearing for respondent numbers
3, my lord.
number 3. And who's for education?
My lord, you can note down NJ Khatanier's name, my lord.
Okay,
I had discussion with
Okay.
him in the morning.
Mr. N.J. Khatunier, Standing Counsel for School
Elementary,
Education Department, appearing for respondent numbers 1, 2, 1 and 2.
7, 8.
You'll be appearing for 3 and 4. Ms. Burman,
My lord.
for 3 and 4.
Yes.
Achha, next
School
one.
education may appear my lord for 7, 8, 9, 10.
School education will be 7, 8, 9, 10 also. One, 2, 7, 8, 9, 10. By filing this petition under Article 226 of the Constitution of India, the petitioners are praying for a direction upon the respondent authorities to reopen and operate 13 primary schools of Burha Sapori area, BURHA-CHAPARI area, which was demolished in an eviction drive. Next para. You should notice a motion returnable on so. Just prior to that, you just say the Learned Standing Counsel for the Forest Department has produced a copy of notification dated 25/4/2023, issued by the Director of Elementary Education Assam, by which by which 10 out of 13 schools have been merged with other base schools. First of the chart is the charge of merger is appended below this one. 10 schools. Next one. At this stage, the Learned Senior Counsel for the petitioners has submitted that the respondent authorities be directed to inform about the distance between the schools that has been merged with the base school. First off, in the privacy view of the court, the said prayer shall be considered later on as the said prayer has no nexus with the prayers made in this writ petition. Next paragraph. Insofar as 3 schools are concerned, as no instructions has been placed, issue notice of motion written about on so and so. Requisite extra copies of the writ petition be served on the Government State and Department Council in course of the day. Next paragraph.
By tomorrow.
By tomorrow, okay. By tomorrow. List and so and so.
Reasonable within,
4 weeks.
can you start a matter? 2 weeks. Simply one instruction. I will have to get.
Okay, give a date then after 2 or 3 weeks.
16/6,
All right.
15. May please your lordship.
Yes, Mr. Sikdar.
Lord, the petitioner before lordship, they are admittedly occupying common castle and they are buried people. And they are staying on the land since last 40 years. And in the year 2005,
But this, what I understand from here is that was a grazing land.
my lord,
For grazing land, we can't issue a direction.
my lord, there are so many judgments of the apex court, my lord. When the
For
chairman-
VGR, for VGR, settlement of VGR land.
My lord,
Give me
That-
one.
my lord, there has been previous writ petition before this honorable court.
Huh.
And that issue, that case was also, visual issue was also raised in that case. And my lord, that part, considering that also this honorable court passed order to consider their case. My lord. Lordship will find in
No, you see,
annexure.
that consideration can't be made because the Supreme Court has come against the VGR land.
My lord.
What is that judgment? I don't remember.
My lord. My lord, lordship may kindly take up annexure 4, page 90.
Page 90.
And that part, my lord, visual part is at paragraph 22, page 103. Under such circumstances, this court disposes of the lordship God.
Yes.
Under such circumstances, this court disposes of the instant writ petition with the direction to the Deputy Commissioner Doran to take a call on terms with Rule 95 of the settlement rules as to whether, in his opinion, the BGR land is required to be wholly or part of it is to be denotified as a BGR land. And if in his opinion it is required to be done, he shall carry out the formalities as required under Rule 95. A read with Rule 55, 56 of the settlement rules. The Deputy Commissioner is to direct it to carry out the said exercise within a period of 60 days from a certified copy of the army. In para 23, my lord, there was specific direction to consider their case. My lord. There was a recommendation by the earlier land advisory committee to grant 1 bigger 5 plus land for them as a reverted people. for their settlement. And therefore that writ petition by the ultimately, my lord. They have to approach this honorable court by a writ petition. Then, my lord, immediately after this, my lord, the petitioners come to know that the government, central government is taking a land for widening of the National Highway 52. And their village is also falling on that, my lord. Village Bandiagaon. My lordship may kindly have a look at page 105. And their village is at 106 under serial number 23-5. Common residential. It's common land, but their land is a residential. There is limited. Government may in the meantime started to take the land by eviction, my lord. And they have started. But our concern is that we have no other place of shelter. Some compensation may be given by the authority on taking note of the Zirats, my lord. Even the government khas land, government can pay the compensation in respect of the Zirats also. That is our limited prayer. We are not objecting the taking of the land, but only, my lord, if they have been given some compensation in lieu of the Zirats, they can manage their settlement in some alternative place. That is their limited prayer. And we have also relied on a order of the government, my lord, in the district of Achar, annexer, my lord, at 11, that even government khas land, in case of government khas land, the government has given compensation of Zirats. Only for Zirat.
Yes,
My lord, I am appearing on behalf of 1 and 2, my lord.
yes.
National Highway 13. Most probably this road is not being constructed by NSA. Properties maybe NSA DCL, but it is not NSA certainly, I think. That's why I have to take instruction. This until and unless proper party constructing agency is not made party, my lord. Implementing agency is not made party. Whatever it will outcome will come, then also whether positive or negative, that will later on, but proper party is to be made. That is why I have to take instruction in this regard whether NSA has.
Get by 2 o'clock, because you see, if he is asking for Zirat, that is his limited prayer.
Yes.
So whether you are a party or not,
I'll-
the Zirat is being calculated by deputy commissioner. It's not calculated by you.
That is it, but ultimately, suppose, my lord, if GST is going to be paid, that is to compensation has to
Payment
come.
will be made later on, not today. I'm
And
not
that-
directing a payment to be made today, but the deputy commissioner must
And
carry
that
out the.
case, that case, lordship, my part is later on. 2 o'clock. I'll be
Definitely,
done.
you are expecting that I would pass an order of payment today.
No, but not only this, I have to submit this or whatever, because we are NSA
No, if-
constructing agency.
If Zirat is the prayer, then notice has to be issued.
Yes,
Yeah.
yes.
Or we can give you time till 2 o'clock to get us information if this is being done by NHAI or not.
But today it will be because
My lord,
today, no.
the notification goes to show, my lord, notification, my lord, annex in page 106,
106,
105, my lord, NSR 5,
yes.
Ministry of Road and Transport and Highways notification.
No, that may be there. There are many agencies,
My lord,
Yes.
not necessarily they will do it.
Well.
If you are a good contractor, you can give it to you also. Correct. But Mr.
In respect of Jagpal Singh, my lord, that settlement cannot be done. In respect of Jagpal Singh judgment, my lord, that settlement on,
Jakpal Singh, that's
Yes.
what I was asking.
yes, 2011-11-3960.
It's okay, it's not, that is not his prayer. He's saying that
Zirat is concerned, I may take instruction.
if Zirat is created by them, they will have a right. Even if they are squatters. But Mr. A.R. Sigdan and counsel for the petitioners. This empowerment and government advocate appearing for respondent number
4, 5, and 6.
4, 5, just number 1 and 2, you write, Mr. C. Barwa, standing counsel for respondent number 1 and 2, government advocate for 3,
I may take
4.
copy of-
3 will be you, okay. for revenue department, Ms. G Hazarika, standing counsel for revenue department for respondent number 3, 4, 5, 6. You'll be for 3 and 7 also then. You especially you'll be there for 7. It's 8. This government advocate for respondent numbers 4, 5, and 6, and the H. Alia for respondent number 7. Next paragraph. The petitioners claim that since the date this since about 40 years, the petitioners are residing in a government land covered by Dag number 5 of village Bandia, BANDIA, Gaon, within bracket Bandia Chapori, bracket close, under Chapai, CHAPAI, Moza, in the district of Garang. Full stop. The said land is a village grazing reserve, and that the petitioners have settled in the said land, and they had been paying land revenue till 2011-12. Full stop. It is projected that the part of their land is being acquired by virtue of notification dated 29/6/2020 for construction for extension of the national highway, and accordingly it is claimed that the petitioners have their houses, buildings, other structures and accordingly, in respect of the said Zirat, ZIRATS, the petitioners are claiming compensation. Next paragraph. The Lawrence Standing Council for respondent number 1 and 2 submits that he is required to take out instructions as to whether the said respondents are the exhibiting agencies. Next paragraph. Issue notice of motion returnable on so and so. The requisite extra copies of the writ petition to serve on the Learned State and Department Council within 2 days. Next paragraph. The pendency of this writ petition shall not be a bar for the concerned authorities including respondent number 5, I, the additional deputy commissioner within bracket revenue and competent authority under NHAI to consider the claim of the petitioners. Next paragraph. The petitioners are permitted to produce a certified copy of this order before the respondent number 5 to bring the order to the notice of the said authority. This sort of works. I'll take a break and come back. I'll take a break and come back.
Item number 9.
Wait, please, Your Lordship. So in this case, the petitioners belonging to minority community and pursuing technical course applied for post-matric scholarship meant for the minority students. Through National Scholarship Portal, online the application has to be made. And after the application is made online by creating a user ID and password ID, the matter gets referred to the institute, wherein the institute will have one login ID. They will make a login and verify whether the documents submitted by the candidates are correct or not. And once the institute approves the same, the matter goes to the district nodal officer, who has to transmit it to the higher authority.
One set of instruction has come, my
We
lord.
have received the producer, she has produced any instructions.
Yes, my lord.
This, who is the, you have applied from where? Shifa Pharmacy, correct?
I am studying in we are studying in that institute. Lecture 3 page 20 is the online application status.
There's a scam going on in the name of minority scholarship.
To petition and preparation.
Where is the document from which institution you are studying?
Page 20, the Lordship will see the annexure. This is the status, Your Lordship, the Shifa Pharmacist Institute.
Shifa Pharmacist Institute. Where is the registration of that institute?
I have annexed that page number. Until and unless they are registered, they cannot verify and approve you. They have.
Yeah, Ms. Brahman, you are saying so many things. You are not referring to this
Yes.
Shifa Institute.
Yes, my lord.
Why this name is not coming up in your report?
That earlier occasion, I was not appearing, my lord.
It's
Just-
okay.
Yes, my lord. I have just gone through the instruction, my lord. That specific instruction is not there. I could not found, my lord. And so far as list of my lord documents are concerned, there are some, they have, I have to take instruction on that point also, my lord. As per last
You call
order,
them at 2 o'clock, get us the information, because I need to know about this Shifa Institute.
my lord.
From the same institute, lordship, some other students applied and they have been
Oh,
approved.
because there is a scam now on earth. There's an FIR there. There are a lot of people who are using these fake registrations, and they are getting that. There's also
It may be there, your lordship.
there's a case registered.
That I have no knowledge, but in this case, your lordship, students from the same institute who applied.
Because
to
you
the-
are they are not referring to the name of the institute, but they are saying head of the institute was tried to be contacted and there is not to be found. You get this information, these two names which are
Right.
appearing in the FIR.
My lord,
I am only interested to know about this Shifa Institute, nothing else.
my lord.
At 2 o'clock.
I'll try.
Lordship, I have also received one instruction, but it's not relevant.
Pass it on. Does it, no, before passing it to me, just tell me, is it relates to Shifa Institute?
I'm appearing in a formal party. I'm here, my lord, WMD department. They have written the district nodal officer is verified the the documents and they have rejected the application. That's all.
No, he says that the portal doesn't, is not accepting it. That's what you are saying.
Online portal accepted, but the district nodal officer has not approved.
But
there is a
instruction
process.
says,
First, the student will apply online through
First page, my lord.
by creating a login ID. Thereafter, the institute who is also registered with the concerned ministry, they will enter through their login, institute login, and they will approve. And then the district nodal officer should forward or approve the same. So it is the district nodal officer who has not approved, saying that
The
documents are
paravise
submitted.
comments, my lord.
You are appearing for whom?
WMD department, welfare minorities and development.
Okay, we'll take note of this also. At 2 o'clock,
Fine,
we'll get the information.
All right.
But to both of you, Ms. Brahman and Ms. Bora, you see this, when you are asking for instructions, you're definitely giving them some idea of what instructions are required. So they say everything which is like beating around the bush. They don't say the actual fact. And the petitioner is, the matter comes up in motion last time, again this time, and we are still there. Why half-hearted, half-baked information you are accepting?
my lord,
You have a
only-
copy of the writ petition, you will
Yes,
just,
yes, my lord. But
In fact, my
last
lord,
night, last night I have noticed the earlier order, my lord, the specific instruction that is required for.
My lord,
So,
on last occasion,
give
the
me some time,
petitioner
I
did
will-
not serve a copy without
you
having
could
a
have,
copy.
you could have asked, because you see, the court has not issued a notice.
My lord.
That is why the matter is still in the motion. If you need a copy, you should always request the court that the other side should supply a copy. If you don't make that clear, you are not getting a copy.
My lord, without serving us copy, the petitioner has filed the case lordship. Somehow I came to know after that. And I am appearing for the first time. But I have gone
Oh,
through
that is wrong
the.
then.
Yes,
No,
my
That
lord.
is wrong.
What happens actually, there is,
No, we don't know, but if she is a standing counsel, she must get a
then
copy.
immediately after I came to know that she is standing, because I immediately supplied her a copy. On the next day of the order, your lordship, on the very next day of the order.
Okay, at 2 o'clock.
My
Of like,
Item number 10.
Okay, then for lack of information, we excuse you, but not Ms. Brahma. Yes,
What had happened? The petitioners are unit, my lord, producing, my lord, the calcinate petroleum coke. And for production of, my lord, calcinate petroleum coke, they need, my lord, raw petroleum coke, which is a petroleum byproduct. My lord, Molecule Refinery, my lord, conducted an auction pursuant to which the delivery order was issued, which your lordships will get at page 55. If your lordship would kindly have a look on the left-hand side at top, my lord. Date of order 28/2/23, last delivery date 5/4/23,
55.
page 55, my lord. Quantity is 1,000 metric ton. And on the left-hand side top, delivery order dated 28/2/23, last date of delivery 5/4/23. So that means, my lord, that lifting of this RPC, my lord, has to conclude by 5/4/23. Now, what happened, my lord, while the supplies, lifting was going on, by a mail at page 56,
Yes.
we were, my lord, asked to withhold my lord, lifting. Page 56. Dear all, this is to inform you that we are temporarily withholding upliftment of the auctioned RPC for so and so ton. It includes, my lord, not only if there are other contractors also.
Just a moment, you are referring to page 56.
Page 56.
Which division?
My lord, I am referring to 266 of 23, my lord.
2662, there is a chart in this.
No. Page 56, my lord, Annexure 6.
Annexure 6, here is a chart.
Yes, it was
Huh.
the end, it was the end, my lord. Here all,
Oh, acha, okay. That is in the below. Okay, I missed out that. Yes.
dear all, this is to inform you that we are temporarily withholding upliftment of the auctioned RPC for 20,000 metric ton carried out on 1st of February so-and-so, wide auction so-and-so, with effect from 25th of March to 15th of May, tentative on account of safety concern in view of refinery turnaround. Basically what had happened, my lord, the Molecule Refinery, when it was initially made, my lord, it was a 3 million ton refinery. Now, my lord, huge expansion work is going. So what had happened because of the expansion activities that is going on, my lord, the quality of the, my lord, this RPC has also deteriorated. But that is besides the point. Here in this case is, my lord, they have stopped us. Now thereafter, my lord, they say you lift it. That is again on page 59. Once they say you stop it, then this time they say you lift it.
Okay.
Now page 59, my lord, kindly see. Dear all, partial amendment to mail circulated on 27/3, which I read at page 55, on withholding of RPC dispatch for safety reasons due to ongoing shutdown activities. We would like to inform you that we would like to restart RPC dispatch with immediate effect on a very restricted manner, since shutdown activities are going on full swing. Therefore, we request you all to follow all safety security guidelines while entering the loading and movement inside the plant. Now, my lord, if your lordship would kindly have a look at 59 capital A. Clause number, new age, na? Kindly see, my lord, serial number 5.
Yes.
New age, that's the petitioner. Now kindly see last date 29/5/23. Now we'll have to start lifting and conclude it by 29/5. Now, my lord, what had happened? There is no clause in the, my lord, terms and conditions which govern the rights and obligation of the parties for the refinery to resort to such type of action. On the contrary, clause 6, which your lordship will find at page number 43, my lord. Page 43, clause 26. In the event of the lot basis auction, any material being found to be deficient in quantity, quality, size, measurement, number, and weight, or description from those stated in the list published on the website, buyer shall have no claim against NRL or the auctioneer, nor shall the purchaser buyer be entitled to seek any annulment of sale or claim for loss of profit, interest, damage, or any other ground except for refund of a part of the purchaser money for the quantities shortages in delivery. So by 28/4, my lord, my time was up to 28/4. My lord, they have imposed so many conditions which are, my lord, protecting their interest. But this is the only condition which protects our interest, my lord. Now you have stopped it, now you cannot ask us to lift it. In terms of section 39 of the Contract Act, my lord, they cannot compel us to perform the contract. So in terms of this clause, my lord, we are entitled to a refund of the amount corresponding to the amount which has not been lifted. It could not be lifted because of their, my lord, orders, not on account of our fault or anything. So this is the, in fact, my lord, in one petition, this honorable court has already passed an order, my lord. Yeah. They were supposed to file the affidavit, my lord. And meanwhile, this honorable court directed, my lord, that no coercive measure will be taken. My lord, in the Daram Setti's case, Honorable Supreme Court said, my lord, contractual terms are not only binding on the contractor or the, my lord, the employee. It is binding on both sides. If there is any clause, then it governs, binds both the parties.
In fact, paragraph 5 says why you are not trying to lift it now.
Yes.
Price has come down.
No, my lord, that is they say. They say. It's not a question of coming down, my lord. In that case, there was one more point regarding their quality. That was their contention, my lord. My lord, I'll just have your lordship's kind attention to one particular clause that will show how the contract is tilted in their favor. If your lordship would kindly come to page 38, my lord. Just to show, sorry, not 38. Please come to page number 40, my lord. I'll just show one clause.
Because this issue which you are raising,
Yes,
perhaps except for the competition commission,
yes.
the court will not be able to deal with it because it's a, once you say that it's a tilted agreement, then that is the only authority to set it right.
Yeah, lordship is in a sense correct. In a sense correct.
But still, what is your point?
Now kindly come to page 40, my lord.
40.
Paragraph 2, clause 2, conditions of e-sale. The prospective buyer will inspect the material offered for e-auction sale within the stipulated period at the site where the material is located and collect composite samples for the testing at their own lab. The bidder shall satisfy themselves about condition, quality, quantity, and measurement of the materials which they intend to purchase. No complaint shall be entertained regarding description, quantity, size, measurement, and weight of the material, as information given in the catalog is approximate and no warranty or guarantee shall be implied. Material shall be sold after bidder have inspected the material and conducted requisite tests on the collected composite samples to their satisfaction. However, it is not binding upon NRL to ensure where the bidder have conducted the requisite test after collection. Suppose in a situation, it could so happen, my lord, by lapse of time because of the expansion activities which is undergoing, my lord, the quality has deteriorated, they will not take responsibility. On the contrary, my lord, they are permitting only 4 trucks to enter daily, whereas we need to enter at least 10 to 20 trucks daily, my lord. On the contrary, they will also say time is the essence of the contract. So this is how it is tilted. In any case, my lord, in this case, we are relying on clause 26 because within the time, if nothing could be lifted, then you are bound to return the money. And to that extent, my lord, we made a representation, which is also pending. They have not done anything. Page 58.
You are now required to lift how much quantity?
Yes, now we are required to lift, my lord. 1 second, my lord.
1,000.
No. 1 second, my lord. Out of 1,000,
3,000
1 second.
quantity ordered.
New is, no, we were ordered 1,000, my lord.
Huh.
Now I think 694 is left.
694. 694 metric ton.
Prorata uplift, 1 second, my lord. No. Short lift, no. 1 second. My lord, what is required to be uplifted is 134. No? 694 to 2,000. Huh? Please come to page 59A, my lord.
No, it's okay. I'm just trying to understand
Yes.
your the submission. Now it is 694.
Yes, according to their own chart, my lord.
694 is to be lifted by you.
Yes. Up till 25.3, I uplifted, my lord, 694.
Achha, so how much is left?
Now it is
580.
134.
134.
Yes.
No, can't be 134.
What page?
694 minus 1,000 would be 306.
439. At page 61, my lord, they indicate.
Quantity is 3,000.
No,
No.
our quantity was 1,000.
No, 1,000. So 1,000 if you lift
I think
694.
439 is left, according to them, my lord. At page 61, my lord.
Yes, 61.
Page 61,
Yes.
last subpara, as such, as per clause 26 of the terms and condition of auction, we would further like to request you to refund us the security deposit of rupees so and so in respect of balance 439.
Means it doesn't, the arithmetic doesn't match.
Match,
Because you-
arithmetic does not
1,000
match.
1,000 minus 694 would be 306 only.
Yes, it looks like.
Okay, yes. So we pass the same order.
Yes.
First, Lordship, yes, that has been already, no coercive action will be taken up, that has been already agreed to. Similar thing.
Okay.
It
I-
can
I'm
be
not
tagged
saying-
with that matter, my
I'm
lord.
not saying so many things. I'm saying that this is squarely
Yes,
covered by
yes,
this
yes,
order.
Yes, Lordship.
I'm not giving a descriptive.
Lordship. Yes.
For Mr. K.N. Chaudhary, I'm a senior counsel, assisted by Mr. N. Barwad, I'm a counsel for the petitioner. And Mr. A. Kalital, I'm a standing counsel for, you're standing counsel or?
I'm not standing counsel, Lordship.
Okay.
Especially
Okay,
preparing. for this.
let me counsel for respondent numbers 1, 2, and 3. Next para. The, in brief, the case of the petitioner is that they were to lift a specific quantity of, what is RPC full form?
Raw petroleum.
Raw petroleum coke within bracket, RPC for short. And in course of the process of lifting, by a email dated 27/3/2023, issued by the NRL, the upliftment was temporarily withheld on account of safety concerns in view of the refinery turn around 2023. Capitalized from the word refinery turn around 2023. Also, by a subsequent mail dated 19/4/2023, the petitioner was permitted upliftment of
First, there was.
the balance, the balance quantity of RPC within
29/5/23.
29/5/2023. Full stop. The petitioner has invoked clause
26.
of the
BRD, they call it, my lord, BRD.
BRD. B for Bombay. BRD.
Business rule document.
Okay, the business rule document within bracket BRD to claim refund of the unlifted amount, unlifted quantity of RPC. First one. The learned senior counsel for the petitioner has produced a copy of order dated 28/4/2023, passed in WBC 2273 of 2023, where the facts are similar, and it is submitted that in this said order, as an interim measure, it was provided that there shall be no coercive action against the petitioner in terms of clause 10 within bracket C within bracket numerical 2 of the BRD. Next paragraph. The learned counsel for the respondents, respondent numbers 1, 2, and 3 has submitted that except for the quantity, auction ID, etc., basic facts are similar. Next paragraph. Accordingly, issue notice of motion returnable on when is the next that case?
Next case, the date was not fixed, lordship. After 2 weeks, it was stated on 4/5/23.
Okay,
So maybe in the next week, matters will be coming.
So it may come along with the other.
Along with the other matters.
okay, returnable on the date when proceedings are WBC 2273 or 23 is listed. Must requisite extra copies of the requisition be served on the learned counsel for respondents in course of the day. Next para. As an interim measure until the next returnable date, it is provided that the respondents shall not take coercive action against the petitioner in terms of clause 10 within bracket C, small c, within bracket small numerical 2 of the BRD.
Fine.
This along with WBC 2273 or 2023.
Well, the other two cases, same, only their outer limit is instead of 29/5, it will be 28/5.
28/5. There are other two matters lifted by 28/5.
Instead of
And-
29/5.
And what is the quantity, Mr.
Yes.
Parva? You please
Yes.
write that quantity.
One second.
You can write and give it to the
Yes.
court master.
Deeply.
11/12, same.
16. 16.
May it please, my lord. My lord, this instant petition should not have come before your lordship in the first place, because this does not really warrant the exercise of extraordinary powers. However, the petitioner is here before your lordship because of the inaction of the executive authority. My lord, the facts in brief are that,
This is a single bench matter, it will go to the revision bench.
my lord, if my lord may kindly.
Yes,
Yes, my lord, single bench.
it's a single bench.
Yes.
Okay, okay.
My lord, the facts in brief are that the respondent number 5 is a resident of my village, and which goes by the name of Uralkata Pahar village in Morega district, my lord. My lord, since some time of being residing in my village, it came to my knowledge that this instant person was declared to be an illegal immigrant by a foreigners tribunal way back in the year 1977 to 78. Thereafter, my lord, when I probed a little further, I came across his voter ID, which is at page number 26, my lord.
If your lordship kindly peruses page 26.
So you are saying that he was declared as a foreigner. Where is that order?
My lord, we do not have the order, my lord. No, my lord, I have not been declared as a foreigner.
No, you are referring to
respondent
the
number five.
respondent.
Yes, ma'am.
Where is that order? You
My
don't have.
lord, I do not have that order. However, since it came to my knowledge, my lord, I decided to follow up the matter. And my lord, a reference was made. It came to my knowledge that a reference was made before the competent foreigners tribunal, and he was declared to be a foreigner.
Where is that?
My lord, I don't have that order, my lord.
Okay.
Hence, when I spoke further, my lord, I came across his voter ID, which is at page 26. If my lord has page 26, my lord.
Yes.
My lord, his name appears as Abu Sahid, and his father's name is late Abdul Karim,
Yes.
and his age is 75 years, and he's a resident of Uralkata Pathar. So he has been a resident thereof. Thereafter, my lord, I came to know that when the NRC process began, he had applied to be listed as a Indian national. And I came across his legacy data, which is at page 25, my lord. My lord, at page 25, that is the original transcript, my lord.
Yes.
My lord, his name appears as Abu Said, whereas in the voter ID, his name was Abu Sahid. And my lord, the name of the village on the top right corner, my lord, appears to be Langia, whereas his voter ID says Uralkota Pathar. Thereafter, my lord, based on this legacy data, his name was entered into the final NRC draft, which is yet to be notified. My lord will find that at page 33. My lord has page
You
33.
see, simple thing.
My lord,
In this writ petition, you are not seeking any relief for yourself.
my lord, yes.
So why would a writ be maintainable?
My lord, my limited grievance here is that when I came to know of all these discrepancies, and when he had applied for a final NRC application, he relied on a voter list of the year 1961. My
You
lord,
can always, you could have approached the border police Morigaon.
yes, my lord, I have duly approached my lord. My lord will look at page 42 of my writ petition. That is the typed and translated copy. The original complaint is at page 43. Therein, my lord, I approached the superintendent of police border Morigaon, where it
No,
specifically
these
stated,
things will never be, these things will never be acted upon. You see, you are, please come to page 43.
my lord.
It's a mere statement, not verified, not supported by affidavit. This is the police will not move on this.
My lord, my limited submission here is that, my lord,
No, let us see, take an example, Mr. Barua.
my lord,
Tomorrow you suspect that, I'll take my own example, that I am a foreigner,
my lord.
correct? Now you write a complaint to the border police saying that X is a foreigner. You don't take the responsibility of this statement, you don't file an affidavit, you don't take, do anything merely because of the petition. Can a citizenship be questioned like that?
My lord, if I may humbly refer to the foreigners report to police order of 2001. I have a copy of the order. If my lord peruses section 2, my lord, of the order.
Yes.
Information to police about a foreigner in certain circumstances, if I may read, my lord. Where any person who has reason to believe that a foreigner has entered India without valid documents or is staying in the country beyond the authorized period of stay, accommodates such foreigners in a premise occupied, owned and controlled by him for whatever purpose, it shall be the duty of such person to inform the nearest police station within 24 hours about the presence of such foreigners. My lord, when I have submitted this representation to the SP border, I was discharging my duty under this order. And this order does not require me to give a sworn statement adducing proof of the same.
He's taking, you please read it again, where a person who has reason to believe
My lord,
that a foreigner has entered India without valid document
my
or
lord,
staying in the country beyond the authorized period of stay,
my lord.
accommodates such a foreigner in premises occupied, owned or controlled by him for whatever purpose, it shall be his duty to inform Therefore, if you believe that one is a foreigner, you just inform the police station that, well, I am accommodating him. This is not a format of complaint. You can't write against anybody who is not being accommodated by you.
My lord, if I may humbly submit, perhaps my lord, the interpretation would be a little different, taking into account a comma, my lord. Authorized period of stay, comma. Therefore, my lord, in my humble interpretation.
No, you see, this is not only one comma.
Hello.
This comma as placed here in English grammar, we call it a bracketing comma. So now you read just as I am telling you, a period of stay, comma, accommodates such a foreigner in a premises, comma, occupied, comma, owned or controlled by him, comma. So these are you see bracketing commas. You put instead of this comma, you put a artificial bracket and omitting it. It still makes sense. Therefore, it is if you have accommodated him, only then it applies. Comma is not a what you call the disjunctive comma here. It's a bracketing comma.
My lord, I'm obliged, my lord. If I may try to convince further, my lord. If my lord peruses the foreigners tribunal order of 1964, I have
You see, I'll give Mr. Parwar, it's a simple question so far as I am concerned.
my lord.
Why would the High Court issue a notice on the authority to examine somebody's antecedents,
My lord.
which makes him, you see, vulnerable, this man,
My lord.
respondent number 5. You could have applied before the police. If it doesn't take steps, your remedy can be others.
My lord,
But
the
you see,
remedy is-
now you want an inquiry to be registered by the High Court. High Court will not be a competent authority to do it.
My lord, firstly, there is no provision of appealing against the non-consideration or
No.
representation.
You see, the relief which you are asking is
My lord.
against this person in the High Court.
My lord, my relief is against the non-consideration of my representation by the SP border, where I have given him an information that this is a presence of a foreigner. You kindly investigate into the matter. My lord, under the foreigners tribunal order, the SP. is
You
the
are appealing
competent
for
person
SP
to
border.
refer.
You are appealing for SP border. Who is the concerned?
NRC popular usually appearing.
Huh?
NRC, SC NRC matter.
SC NRC.
Yes, name is.
You have served copy on them?
Name has already been shown in the.
Yes,
congressman.
shown.
My lord, my-
Just call that item. This is
16.
SC NRC. Mr. Das, SC NRC. After some time, let them come.
My lord, I'm obliged.
Just a moment, Mr. Verma. One more question. Have you made any statement that against him and you, there are no litigations or quarrel involved?
No, my lord. My lord,
Is there any litigation or what you call complaint by you
no, my,
pending before any authority?
no, my lord, no, my lord.
You will be required to make that statement. Because you see, if you have some other grievance and this is the way to take revenge, we'll have to take care of it.
My lord.
Yes, Mr. Deka.
Lordship, we are the petitioners residing in the Sitalmar village. Admittedly, they were possessing government land. And cozy fine were collected from them. And some of them were given benefit under the PMHY scheme also. The residential houses were completed under the same scheme also. But Lordship, on 25/1/2003, there was a joint eviction done by the district administration of Nagaon and Sonitpur district.
Yes.
Lordship. So here the lead petition is filed just for seeking some financial assistance as they won't have any shelter.
Yes, Ms. Bhargava, what is your stand here?
My lord, whether any scheme of such, any available scheme is not, it
Lordship,
has to
turn to
be
page
in
16, Lord.
instruction, my lord.
Lordship, page 16.
16.
Yes, 16. The beneficiary name is also there.
No, that is okay, but
No,
but
for
if the land is
rehabilitation-
but if the land is a government land,
Yes, my
Yes,
lord.
Lordship.
then
We are ready to
this
leave, Lordship, but at least some kind of compensation given. Lordship. So
Then they
three
have
then
also
lordship,
stated
so-
they are paying TOSI fine, my lord.
Just to protect their fundamental right to live. that's it. They don't have any cause to live.
Relief claim for rehabilitation of those people, my lord. Whether any such scheme is available,
You tell us basically issue a notice,
notice may be issued, my lord.
Mr. A. Bekal and counsel for the petitioner. And Ms. M. Burman and a government advocate appearing for the
1, 3, 4, and 5.
respondent numbers 1, 3, 4, and 5. You are appearing for finance?
My lord.
2, okay. Ms.
Yeah.
P.R. Mohanto and the standing counsel for respondent number 2. The petitioner claims that he was occupying a government land and
TOSI fine or-
under the PMAYG, PMAY-G. He was sanctioned funds to construct a house, which he had done. But in course of an eviction drive held on
25/1/2020.
25/1/2023, his house was demolished. Accordingly, this writ petition has been filed seeking compensation at least for rehabilitation. Next one, issue notice, return of announcement, so 4 weeks.
My lord.
Extra copy of the detention be served on the state and department council in course of the day. Next paragraph. It is provided that in the event state has any policy for the rehabilitation of persons who were evicted after they were allotted funds under PM. What is it called? PMAY-G. The pendency of the writ petition shall not be a bar to examine the claim of the petitioner. Let's start with 4 weeks.
Lordship, item 17, 18, 21, 23, and 30 are same. cause of action.
Item
18, 21, 23, and 30.
18, 21,
23, and 30, Lordship.
23, and 30. Okay. Right. Same.
Yes.
This foreigners, this book somebody gave, after something.
20. Item number 20.
Mr. Chaudhary, you are sitting, Sai Chaudhary. It's not your matter. Not a present call for the petitioner. This,
In this matter, my lord, petitioner is, Vivan says they have agreed by the notice issued by the All India, my lord. And so far as area of respondent is concerned, my lord, I find nobody is here, my lord. Name is not shown, sorry, my lord, in cause list. Name of.
No, here what is required is, you see, in this case, the petitioner was asked to be evicted.
Yes, my lord.
And and the Oil India says that they have their right of way, ROW.
It's 60.
So if ROW is issued by the deputy commissioner, it will be the deputy commissioner who will say that they have ROW on that.
But they have met 5, 6 and 7, the All India Party. My
It's
lord.
okay, I'm just postponing it.
My
I'm
lord,
not doing it.
name is not announced.
Yes, next item. 22.
22,
May please your lordship.
Yes.
This matter, it is some personal difficulty reading. So this matter may kindly pass off for the day.
For the day,
Yes,
Okay.
lordship. Or
pass over the day as prayed for by Ms. Annie Roller, the counsel for the petition.
lordship, can it be on Wednesday, lordship? Yeah. For the first days.
Okay, make it Wednesday, at least on so and so.
Oh, yeah, lordship.
24,
May it be your lordship.
Yes,
My lord, the petitioner is aggrieved by the order passed at page 56 on 20th April 2023. I am a properly elected and approval accorded chairman of a cooperative society. On a complaint made after 5 months, it was set aside. I will place the other facts. The impugn order is at page 56.
where is your approval first?
My lord, I am placing, my lord. My lord, I take your lordship to from the very beginning, my lord. At page, your lordship may turn to
No,
page.
other things we are accepting, but just the approval order.
Just
You are
the-
saying that you are the approval was
My lord,
given. Where is
my
that?
lord, my lord. I am placing my approval. It is at page. Yeah, 53, my lord.
53. Thirty-seven, 22.
37, 20. And a complaint was filed after 5 months at page 54. My lord, then if your lordship permits me, I take lordship permits me, I take your lordship to page 17. From the very beginning, I will chronologically, I will place the facts. Page 17, annexure 1. Your lordship has got it. This is the annual general meeting where resolution number 8, formation of the new board of directors, it was approved. 29/7/22, your lordship has got it. Then at page 19, resolution number 8, formation of new BOD. Next, page 19. An observer, the junior inspector auditor cooperative society Hojai is appointed as a departmental observer. On 29 July, your lordship has got it. Page 19. Then page 20. This was the notice. Agenda number 2, selection of chairman and vice chairman of the newly elected board of directors. Then, my lord, from page 21, these are the notice sent to all the members to Peon Book. And for every notice, your lordship will find at page 21, the notice start. At page 22, they are the witnesses. This notice was sent to everybody.
No, once you're showing me the document, this is For the first meeting, they appointed a observer.
observer,
This appointment was on 29/7/22.
my lord, and.
Correct.
And
On 29 itself, you issue a notice and the first meeting was held on same day.
same day, and my lord, and the election
Is-
to be held
is-
on 37.
Is that permissible to hold the meeting on the same day?
Next day, my lord, the election is on next day, 37.
No, is it permissible to have the election in
When
that
the
manner?
board of directors meeting, because I am agreed with the board of directors, not on the board of directors meeting, my lord, where they will elect the chairman of the. This is the first meeting is going to be held. Your lordship may turn to page 20. It
No, Under
is,
the act, how many days notice is required to be given?
well, it is not like a panchayat act. It is a cooperative society. We can hold it the same day. In panchayat act, it is different. So 15
Okay.
days notice. is given. My lord, here, it is 29/7, and in page 20, your lordship will get it. Assistant Registrar of Cooperative Society, the first meeting of the newly constituted Board of Directors will be held tomorrow on 37/22. Next, my lord, notices are sent and witnesses are there. Till page, I have given notice to everybody, till page 43 in vernacular and others there. And in the peon book, your lordship will find at page 44. Serial number, the horizontal page, serial number 1 refused to accept from 10, 11, 12, 13, 13, 14, 15, they refused to accept. Then, my lord, the vernacular of the peon book as page 45 onwards. Then, my lord, your lordship will find at page 47 on 37. Agenda number 2, selection of chairman or vice chairman. My lord, I would trouble your lordship to serial number 3 and 6. These two persons, my lord, because they were present, they have signed it, BOD members, 3 and 6. And ultimately at page 48, the resolution number 1 and resolution number 2 has been, lastly, the president today meeting that thanks and given, and my lord chairman, vice chairman, these were elected. My lord. Page 48. These were elected. Then, my lord, page 53, which I have shown earlier, the approval was accorded by the assistant registrar. Page 53.
Yes.
Next, page 54, there is the complaint comes after 5 months. With due respect, we beg to inform 15 members of board of directors. In the meeting which constituted and elected me, there were 8 members. Your lordship may look into it. There were 8 members of the total 15. So the quorum is fulfilled. My lord, were declared elected on 18/7 and after election held on AGM on 16/7/22 as per rule, president, vice president of the society are to be selected by the newly elected members in the first meeting of the board, but till date, no first meeting is held. After 5 months, till date, today, no meeting of the board is director is held. Therefore, steps should be taken to elect president and vice president of the society. First meeting held on 27/12. 27/12, my lord, these are the persons who made this representation, and now your lordship will turn to page 59. Meeting of the board of directors of 27/12, nobody was present. Page 59. And they made a complaint. And ultimately, the impugn order comes. On 20th April, stating that, my lord, in the second paragraph, heard the petition and the respondent, perusal of documents submitted by both the parties. It is from the observers such and such, Hojai, that the first meeting BOD was conducted on 29 in the presence of 8 numbers of elected members who unanimously selected such and such a president, chairman of such and such, which according to the petitioner was not a fact but a manipulated report for some vested interest. The petitioner said they are not at all informed about the meeting. So authentic and convincing proof regarding holding a BOD meeting of selection of president and vice president with prior information to all the elected members of such and such could be produced by the respondent at the time of hearing. Therefore, the board of directors is hereby directed to hold a fresh meeting of the selection of president, vice president with prior information to all newly elected members of such and such is requested to make necessary action and hereby directed to take necessary.
Who is appearing for corporation department?
My lord, before that, my lord, can I take your lordship to one thing?
Just a moment. Your opinion for Corporation Department?
Corporation not. That's catalog.
Hmm?
That's catalog very disparate.
His name is shown. 24. Yes, Mr. Rajouri.
My submission, my lord, the peon book and the peon was not examined. My lord, the observer was not examined. Witnesses to the notice was not examined. Moreover, my lord, in the complaint, my lord, two names are found, my lord, like serial in page
No,
54.
you have not annexed the copy of the notice issued to you for that hearing.
My
In this
lord,
proceeding.
because we are present, that was there, it's admitted fact. It is stated there, here, heard the petitioner and the respondent. Both of us are present.
It's okay. If you don't produce the document, then how they will come to know about it?
About my lord, what, my lord?
The peon book, you say that peon book was
lord.
not examined.
My lord, what has happened, my lord, the observer was himself, because the lineage register has said the observer was present. Observer was not examined. And my lord, your lordship may find, I am placing another two things, my lord. Your lordship may look into the complaint at page 54. Serial number 8, and Firoza Begum, serial number 2, no? And serial number 2. They have made a complaint and they were present in that meeting, my lord. Earlier, I have stated that 3 and 7, my lord. They, in the complaint, page 54, serial number 2 and 8 are the same person who attended the meeting. Now, at the behest of somebody, my lord, they are making the complaint.
Okay. Heard Mr. Speaker also did an counsel for the petitioner. Now I present call for the Corporation Department. Next, madam. By filing this repetition in Article 226 of the Constitution of India, the case projected by the petitioner is that he was elected as the chairman of, what is the name of the society?
Nakhuti Samavay Samiti Limited. Nakhuti. In page 47, my lord, place office, your lordship will find the address.
47.
Place office, Nakhuti Samavay Samiti
Okay,
Limited.
Nakhuti, Nakhuti, Samavay Samiti. In the first meeting of the Board of Directors held on 30/7/2022, it is projected that notices for this said board meeting was issued on 29/7/2022, and the Assistant Registrar of Cooperative Societies, by an order dated 29/7/2022, had appointed one Tapan Kumar Das, Junior Inspector of the Auditor, as the departmental observer. Full stop. Later on the basis of complaint made by several members of the cooperative society, a proceeding was held in the office of the Registrar of Cooperative Societies, Assam, and by order dated 28/4/2023, the said authority returned the finding that there was no that the complainants were not informed about the meeting, and that no authentic and convincing proof regarding holding of the first Board of Directors meeting could be produced. First of the learned counsel for the petitioner has submitted that although the observer appointed by the Assistant Registrar of Cooperative Societies was present, his statement was not recorded before setting aside the election held on 30/7/2022. Full stop. Issue notice of motion returnable on returnable in 4 weeks. Requisite extra copies of the petition be served on the learned. Departmental Council appearing for respondent numbers 1, 2, and 3. The petitioner shall take steps for service of notice on the respondent numbers 4 to 13 by registered post with AD. Post office. In addition, the petitioner is at liberty to serve notice on the said respondents by way of Rasti and
I'm
by
sorry.
way of there, and to produce a proof of service by way of an affidavit on the next day.
My friend has come.
Yes.
In fact, what has happened? Well, in search, my lord, I have while searching, my lord, the registry has, my lord, shown the name SC Cooperative Society. So therefore, the name is not reflected. They normally give a comma, my lord, and therefore, my lord, it escaped our notice. Just now, my lord, I have been informed
Okay.
that the case has been listed, my lord.
Okay.
So the brief is not with me, my lord.
You take a copy, we'll take it
Ma'am.
up at 2 o'clock. Because
Ma'am.
he's showing only 2 things. Number one, that the Assistant Registrar of Cooperative Societies,
My lord,
he appointed an observer
my lord.
for the first board meeting.
Okay.
He gave a report. Obviously, when he's an observer, he must give a report. Thereafter, on a complaint, the election was set aside. Selection of petitioner as chairman was set aside. Now, although this observer was present, his statement was not recorded, neither his report as to the election was taken into account.
My lord, another thing, my lord, the persons who made the complaint, they were present during my election. Those were.
So that is okay. One may still say that I had no information, I went there
My lord, can it
You-
be tomorrow, my lord?
tomorrow.
Right.
Okay. Okay, then tomorrow.
I'm sorry, my lord.
This order you maintain, just type it out. Tomorrow I'll be spending less time. Okay.
Obligation. I'm sorry, my lord.
Mr. S.K. Talukdar, and the formal order will be both sides are represented. Mr. S.K. Talukdar and a standing counsel for the Corporation Department submits that he has missed the matter. And on his prayer, lists the matter in the motion column tomorrow. It will be 23/5.
I'm deeply obliged.
Okay. So therefore, only if there is an observer given by the authorities,
Right.
at least that statement must be recorded.
Correct.
What is saw.
Correct. Obligation.
It's only that much.
25.
Madam, kindly be adjusted for the timing, madam. Next,
Mr. Roy Chaudhary, just a moment. I remembered something. I just for a smile, for the sake of smiling, I'm just pointing it out. You know, in many times we attend marriages. We don't even see the bride and groom. Meet the relatives of persons who have invited you. Supposing X is your friend, he has invited you, meet him, have your food and come out, and then somebody asks you, who is the bride and groom? You say that I don't remember.
My
I've
lord,
not even seen that.
like this election, my lord, the basic fundamental of the marriage was the food, but that was not missed. my lord.
Okay. Next item. Yes, Mr. Chaudhary, you are just on time.
I'm sorry, my lord.
No, you are just on time. Don't be sorry. You are sorry for coming on time. No, no.
I thought that one already, madam, you was called up.
No.
But this matter is very, Vega campus, my lord. But whereas your lordship is very aware of the electricity Act section 5. Under the act, my lord, franchises were my lord appointed to collect the revenue, etc. my lord. So these petitioners, my lord, they have been also my lord, second petition also, my lord, item 5 and 26. my lord.
I can only issue a notice at this stage, Mr.
Otherwise,
Chaudhary.
31 same, my lord.
I can just issue a notice at this stage because the termination has already taken effect.
No, not yet, from 1st June.
1st June.
1st
Okay.
June. One day take to page 56, but Mela Koda is already there, my lord.
Yes, you can get us information.
Yes.
We'll give a short date. We'll take it up on Friday.
Otherwise, it's only a termination notice, my lord. 30-day notice has been given to them, my lord.
No, no point after they are terminated, no point coming here. Then you'll say that termination has already taken effect. Correct.
Page
We have to
56.
come before the termination takes effect. Friday then?
Friday.
We issue a short notice,
Wait,
notice of motion,
come-
okay.
Come up with the instruction.
Mr. H.R. Chaudhary, then senior counsel, assisted by Mr. M. H. Chaudhary, counsel for the petitioners. Also had Mr. A.
P. Chaudhary.
P. Chaudhary, Lamal, standing counsel for the APDCL.
Respondents number 2, 3, 4 and 5.
Respondent numbers 2, 3,
4 and 5.
4 and 5 will be for one.
Not the government will appear.
Okay, one, so,
Forward, sorry. Forward.
I always forget your name.
P. Deori.
P. Deori, no, I'm sorry. Mr. B. Deori, government advocate appearing for respondent number 1. Next paragraph. Agree by the order of termination of franchisee contract by order dated. Where is the termination order? Termination order dated,
Page 45.
2-5. Page 45.
dated 2/5/2023. From the present petition has been filed under Article 226 of the Constitution of India. Explanation notice of motion returnable on, give a date of Friday, 26/5/2023. As it is submitted that the termination would take effect from 1/6/2023. Next, requisite extra copies of the application be served on the state and departmental council in course of the day. List also, so 26/5. Get the information on that.
The one that page 56, just have a page 56.
56.
Already some other cases are pending also. In that case, a filing termination was given and that was my, some relief was given by page 56. It is submitted by so and so that the, yes. The final termination notes have already served.
Okay, I'll make it clear, the on which date the pair for interim relief in terms of order dated 2012-2019 passed in WBC 9467 of 2019. Shall be
9467.
9467 of 2019 shall be considered.
31 same parties, only
Okay.
petition was different, but
Item
31
31, okay.
same.
Okay.
Implement was same.
Okay.
Always.
Because Mr. Chaudhary, on the next day, you also be prepared on that question, because you see this, these are agency. And insofar as the termination is concerned, if under the agency these terminations take place, will be looking at this with an angle that when there's a termination of contract of service,
That's true, my apparently it is
Then-
contact, but it comes from section 5 of the electricity act, my
no, that is okay, but that principle of 14
Yes. it is-
specifically also will
think
also
that
apply.
13
It's
goes.
okay, but I'm just putting you that question.
But
If we are hearing
that's-
that on that day, you will be prepared
I
with
am
that.
aware of
It is otherwise a determinable contract.
It's okay, but I'm
Yes.
putting Mr. Chaudhary to notice so that he can advance his argument on that day. Be prepared with that.
So that I was expecting that question will come from your lordship.
Deeply appreciated.
This bad habits die hard. Resume at 2.
There is no such difficulty as that portal has been closed, my lord. It is closed on 1st of January 2023, my lord. So they are suggesting that if the pharmacy concern, institute concern has verified the documents physically, they can send it to the state coordinate officer, my lord, so that they cannot be missed out for that application, my lord, that scholarship.
If required, lordship will that student will
Lordship, I
personally
have
appear
also
with the
received one
documents.
instruction. I have also received one instruction.
That respondent number 5, they are right now that Cipher Pharmacy Institute is, they have no nodal officer right now, my lord. He has already resigned and accordingly, that verification part is yet to be done, my lord.
So who will do it?
So if they are in his, probably that institution have some officials, my lord, who can take the responsibility on behalf of this nodal officer, their nodal officer, my lord.
Institute already verified your lordship.
No, it
No,
is,
No, I'm not being able to follow. This respondent number 6 is a nodal officer.
yes,
He is no longer there.
no, he is there, my lord.
Then,
That he has made communication regarding physical verification of the particulars of documents and particulars of the concerned petitioners, my lord. He has written letter and communicating with the institutional administrative officers also of respondent number 7 for for providing the documentation for verification, my lord. Once it is done, my lord, thereafter they can forward it to the state nodal officer, my lord. That part was left, my lord, because of which in the meantime that portal is also closed, my lord. So they are intending to do it physically if that verification is done at the earliest.
so Mr. Laskar is offering that all the petitioners will
Appear
send their documents and appear if required before the CDC signature.
Yes.
If he wants a physical verification, let it be done. Heard. Mr. M.S. Laskar and counsel for the petitioners. Also heard. Mrs. M. Burma, Leonard, government advocate appearing for the respondent numbers
405.
2, 3, 4, and 5.
I'm appearing.
No,
Then 4
Mr.
and
Mrs.
5.
Burman will be appearing for 4 and 5.
4 and 5, my.
4 and 5, and Ms. M.D. Barat,
Standing counsel.
standing counsel for
WMD department, madam.
WMD,
MD. Welfare of
oh, sorry,
Minorities and Development
WMD department,
for 2
appearing for respondent numbers 2 and 3.
Madam.
So CGC will be appearing. CGC, Mr. K. Gogol and CGC appears for respondent number 1. Next paragraph. The petitioners claim that they are otherwise entitled to a minority scholarship for the year 2022-23, as they are pursuing 2-year diploma in pharmacy course from Shifa SHIFA Pharmacy Institute at Silchar. Within bracket, respondent number 7. Poster. An advertisement was issued by the Directorate of Char Area Development, Assam, inviting online applications to National Scholarship Portal. Poster. It is projected that the petitioners had submitted online. How many petitioners are there?
Total
9.
9
All the
petitioners
9
are there.
petitioners have submitted online applications. And it is claimed that the respondent number 7 had verified and approved their applications. However, the grievance of the petitioners is that the district nodal officer, within bracket respondent number 5 and 6, did not verify the applications for which their applications were rejected. No, not for which, and their applications were rejected without disclosing any reasons. Next one. The learned government advocate as well as Mrs. M.D. Bara, learned counsel for the WMD
My lord.
department, have produced the respective instructions whereby it is projected that instructions full stop. The learned departmental council has projected that the district nodal officer has reported that he had frequently tried to communicate over mobile phone with the head of the institution and the institutional nodal office to submit relevant document in support of the post-matric scholarship, but they failed to submit the same within the stipulated time. First of, insofar as the no, it is further projected that there was a large-scale scam in respect of the post-matric scholarship. Where is your document, that scam you said?
My lord,
This is the submission of government advocate. Has submitted a large scam and therefore FIR has been filed, which is registered as,
annexure 3 is that my lord, letter.
just give me the FIR number. Down below is the FIR number,
Yes, my lord.
Silchar PS case number. You-
FIR number 53/71, 2023.
Dated 7/1/2023. Next, on a query of the court, the learned government advocate has submitted that she has spoken to the concerned authorities and that the respondent number 7 institution was not targeted in the investigation for fraudulent withdrawal of post scholarship money. Full stop. It is also submitted that as the online portal is no longer functional, as the period has already expired, the respondent number 7 can forward the physical copies of the verified
My lord,
documents
for verification purpose.
to the district nodal officer, Silchar.
My lord.
For processing. Next, issue notice returnable on, give a fixed date after 4 weeks, so and so. Requisite extra copies of the retention be served on the government, state and departmental council in
It may
course
take
of the
some time,
day.
your lordship. Instead of this, if we are allowed, we can go and submit the documents, your lordship.
No, without, you see, without response, I am not disposing of our petition.
We are intimating with the respondent number 7, my lord, as they have not come up. So I think
Lordship,
notice has
direction
to
may be
go, my
given, and
lord.
since we are the
I am not
students,
disposing of, at no cost I am disposing of without understanding the respondent's stand.
then we may be allowed to.
We are
take
permitting
justice
that.
of this.
We're permitting that. The petitioner shall also take steps for service of notice on the respondent numbers 6 and 7 by registered post with AD. So liberty is also granted to serve notice by way of dusty by routine process through the registry of the court and upon service. And affidavit of service shall be filed prior to the next report listing. Next para. Pending further adjudication of the matter, the petitioners are at liberty to move the respondent number 7, i.e. Shifa Pharmacy Institute, with a representation to forward their physical documents to the nodal officer, district nodal officer, Kachar Silchar. And on receipt of such request, the respondent number 7 shall send the duly verified documents physically to the district nodal officer, Kachar Silchar, Assam. Next, list on so.
My lord, SCWMD may be reflected in the cost sheet.
Okay, the registry shall reflect the name of SC
WMD.
WMD
My lord.
in the causes for respondent number
2 and 3.
2 and 3 while listing the matter next.
I'm deeply obliged, madam.
Oblige. You take back your instructions.
26.
May I please, your lordship?
Yes.
Lordship, the petitioner hearing is the president of the Students' Union of Assam University, Silchar. Now may I draw your lordship kind attention towards page number 21, which is annexure 21, annexure 1. Lordship, it is the memorandum for finalizing social week dates of Assam University, Silchar campus.
Just a moment. Just.
Lordship. Lordship, page 21.
So in college education matters, we are not interfering. When to give a holiday, when to have a college week, when to give you off classes. This is something the High Court will not entertain.
Lordship, but there is a clear violation of the.
You are in a college, go and read. You want to do college week, you leave the college. You want a holiday for that.
No, Lordship.
Then that's your prayer. The entire week, social week classes are to be suspended.
No, Lordship, actually the social week has already.
If you want an order, I'll place an order that it should never be suspended, even for a minute.
Lordship, moreover,
This is something which I will not encourage.
Lordship, actually, the.
You see, what would happen to the litigants if all the judges and all the lawyers take a vacation? What would happen? You want to have a sports week, you have a vacation. What happens to a litigant? No. You are there for education, do that education. If you want to do that politics, you come into politics. This is, I will not entertain. I'll dismiss it in limine. For college week, you have come to High Court.
Lordship, my prayer was not for. that.
No. You ask the petitioner to be here for a debate in whatever subject he wants. On a Saturday, I have a debate with him on whatever subject he chooses. No. You should, what is your marks in metric?
Lordship, that I am not. Well
That we understand. That we'll never know. Now he wants a holiday for the entire week.
Lordship, we don't want a holiday, but actually. what-
No, I'm not encouraging. You have a holiday, you don't have a college week. Nothing is going to happen.
Lordship,
The rest will not fall.
Lordship, that has actually been encouraged by the respondent parties, Lordship. And.
No. This is something I'll not, your representation to be disposed of. No question.
Lordship, the,
To install boys voltage list to so ground be repaired for transportation of vehicles. Then you want gate timings to be altered. You want a social week, certain power weighting, weightlifting.
Exactly, Lordship, but my lord, if may you turn now to page number 22, there, my lord may.
No, let me ask you a question.
Lordship,
Is it a part of your class education curriculum?
no, Lordship, no.
Then
Lordship, that is why the petitioner is here before this honorable court. The signatories who have submitted the memorandum to the respondent parties, the petitioner is not a part of that. The GS on violating the constitutional norms has submitted the memorandum to the respondent parties, and the respondent parties, after the petitioner.
who are you?
I'm the petitioner, Lordship, the president of the student union, Lordship.
At 42 years, you are a student union leader. Very good. Strong foundation. How many years in one class? How many years? How much foundation you have laid? How much deep is your foundation?
Lordship, I'm quite confused, Lordship. Is it item number 26, Lordship, daily list?
Shubhamoy Chanda,
Yes, Lordship, exactly, Lordship.
this is your matter.
Yes, Lordship.
She is 42 years. So how deep is his foundation? How many years in metric? How many years in pre-university level? How many years in graduation? Any idea? At
Lordship.
42 years, how much time is spent in?
No, Lordship, I have not 42 years, Lordship.
I don't know. Then we'll dismiss your petition in limine. This is something we'll not encourage.
This is nothing but a lordship entire politics.
I understand.
And lordship, moreover, the social week has already been over today. It is going to be over today by 4 o'clock.
At 4 o'clock, it will be over.
Lordship.
Lordship, a representation is pending before the Vice Chancellor, Lordship. That
I
must be
understand. You see,
considered,
I always gave an example in my courtroom.
Lordship.
I'll tell you a small story. In Rajasthan state, there was a young boy who was a minor and was terminally ill. He was going to die. As a last wish, he made a request to the government, and the government accepted his last wish when he was a minor, appointed him commissioner of police for a day. In the morning, he was appointed, 5 o'clock, he demitted office. Correct. I also have a strange plan. In my home, there is a terminally ill person. He wants to walk to moon. So he has submitted a representation before the governor saying that a road be built from his house to the moon so that he can fulfill his last wish. So there is a representation pending. And you are now appearing before me for that for the petitioner, saying that my representation be disposed of. Correct? Is it entertainable? Then for college matters, you don't come to court. Whatever you are for it or not for it. You see, you've seen that 42 years. In the cost title page, cost title 42, in the affidavit it is 42. So if you have a strong foundation,
Lordship, actually, the matter was filed in a very rash manner, so it
so
has-
therefore he became 42.
Lordship, it
So
may
we'll
be
dismiss it
pardoned,
on that
Lordship.
ground.
Lordship,
We'll dismiss it on that ground. Don't be so fast, because I am very slow.
Lordship, may kindly pardon me and kindly consider the representation, Lordship. The subject
Consider
has
it.
already.
I consider it. For college, go to there.
Lordship, that
You
was
have-
pending, they are not.
You participate
entertaining.
in the arm wrestling competition.
Lordship,
If you can't succeed in weight, give the file to him. If you can't succeed in weightlifting, participate in arm wrestling.
Lordship, but there was a clear constitutional violation of the students' union, Lordship. Lordship,
Can't help it.
where will the petitioner go if the respondent-
Politics. Politics. You can have everything turned down. Next day you take constitutional decision. Heard this, sir?
Yes, would be, Lordship.
HOB counsel for the petitioner. Next for that. And Mr. S.C. Kyal, Leonard, standing counsel for the
Assam University.
Assam University. Next para. The General Secretary of the Assam University Students Union submitted a representation before the authorities of the Assam University to organize a social week from, what is the dates?
15 to 21, Lordship.
From
15th of May to
15/5/2023 to 21/5/2023. Full stop. The petitioner is the president
Yes, Lordship,
of the State Students Union,
of Assam University.
and it is the grievance of the petitioner is that he was not consulted before submission of that
Memorial.
representation. First of all, accordingly, the learned counsel for the petitioner have submitted that as his constitutional rights have been violated, he has approached this court for a direction upon the respondent authorities to dispose of his representation as though he was the president of the Assam University Students Union. He is kept in dark. Next para. The learned standing counsel for the respondents has opposed the respondent numbers 1 to 5 has opposed this.
1 to 4.
1 to 4 has opposed this, opposed the prayer made in this writ petition. Next paragraph. The writ petition is not entertained and dismissed in limine on the following grounds. Number one, that the General Secretary of the Assam Students, All University Students Union is not a state within the meaning of Article 12 of the Constitution of India. And therefore, writ will not lie against the General Secretary, respondent number 5. Number 2, that that as per the affidavit shown in support of this writ petition, the petitioner is 42 years of age. Therefore, it appears that the petitioner is a professional student with a large experience as a student, and therefore this writ petition is vitiated because of inter-college rivalry. Full stop. Number 3, that if the petitioner, being the president of the Students' Union, is aggrieved by the action of the secretary, the petitioner has alternative remedy of moving the Students' Union to have the matter resolved. And therefore, the writ court, on all these 3 grounds, would be slow to interfere in matters relating to students and academic atmosphere in a university, and it should be left open to the university authorities to resolve the issue if the Students' Union can't resolve it amongst themselves. Next paragraph. Therefore, the writ petition case and the same is dismissed in limine. Without issuance of notice on the respondents.
27.
Yes. Yes, Mr. Ahmed.
Case, my lord. I am seeking the direction for obtaining some necessary document, my lord, in the accident case, my lord. My lord, my son died in accident in the year 2012, my lord. And accordingly, the Soigao PS case was registered. Height Soigao PS case number 146 2012 under section 279 304A.
I don't understand why you have come in a writ court. You see, you are projecting that your son died in the road accident, right?
Yes, ma'am.
You're not getting the copy of FIR and all those things.
FIR postmortem.
You see, read the relevant part of the Motor Vehicles Act. The law says that the accident report will be forwarded to the tribunal. So if it is not there, you can always approach the tribunal and get the records called for. Why a writ court? Give that Motor Vehicles Act.
Accident report is already prepared.
No, whatever record is required, MSCT tribunal can call it. Mr. Parmir, you are aware which provision? I forgot those provisions. (166), right? That name petition. Yes, look at this. C 159 section. Please read loudly. I have these things I have read long back. I'll refresh my memory. Please read it loudly.
My lord, I have filed a representation before the.
No, it's okay.
RTI,
Please
my
read
lord,
that.
because
Please,
of the
please,
police,
please
my
read that loudly. I forgot. These things I have read long back. I never refreshed my memory on that. Please read loudly.
Punishment case 33, my lord.
No, no. Is it very difficult to read at section 159? It's difficult. Please return the book. Please return the book, Mr. Ahmed. I opened the book for you. That's okay, Mr. Ahmed. We can't
Yes,
stay. We can stay idle for so long. Please return the book. We'll permit you to move the tribunal. The tribunal will call for it if you have not given it. Mr. A.N. Ahmed, counsel for the petitioner, and Mr. D. Upamanand,
3 and 4.
study counsel for respondent number
3 and 5.
3 and 5. And you are also there?
Yes.
Mr. Sharma, government advocate appearing for 1, 2, 4,
1, 2, 4,
6 and 7.
6 and 7.
Next para. In brief, the case of the petitioner is that his son, aged 14 years, died in a motor accident which occurred on 5/6/2012. So stop. An FIR to the effect was lodged by the brother of the petitioner, namely Munser Ali, Munser Ali, which was registered as Jurshim Ali, Jurshimali, Police Outpost, White GD entry number 78, corresponding to Chaigaon PS case number 146 of 2012 under section 279/304 capital A IPC. Full stop. It is projected that accident information report was prepared on 15/6/2012, which contains all the necessary information regarding the accident. Full stop. However, the petitioner has not been able to collect the relevant documents in support of the accident. Full stop. A petitioner claims that he had filed a claim petition before the Motor Accident Claims Tribunal at Guwahati
2804.
in the year 2019, being MSC case number 1581 of 2019, but the same could not proceed in the absence of documents.
Yes.
Full stop. Next paragraph. Having regard to the demands raised by the petitioner, the court is of the considered opinion that under the provisions of section 159 of the Motor Vehicles Act, it is provided as follows. Full stop. Therefore, from the above, it would appear that the information given regarding a road accident would be sufficient for the claims tribunal to register a proceeding. Full stop. The next paragraph, it is projected in this petition that the petitioner has not been able to obtain a copy of the charge sheet, MVI report, post-mortem report, etc. Full stop. It is also projected that RTI application has been submitted before the Superintendent of Police Amingaon for the documents which was not and only the copy of GD entry and copy of the FIR was provided to him. Full stop. Next paragraph. In the considered opinion of the court, a charge sheet submitted in the criminal proceeding is not a document which can be issued under RTI. And therefore, if the petitioner is the aggrieved person, he can always apply for a certified copy of the charge sheet from the records of the case where it is submitted. Full stop. Similarly, a postmortem report is also not a document which can be furnished under the RTI Act, as it is a record which is to be tagged with the concerned criminal proceeding. Full stop. So long as the criminal proceeding is not registered, the documents are available in the prosecuting inspector's office. Full stop. The only item which is left out is the MVI report, which the tribunal is not powerless to call. Full stop. Call if such a document has been prepared. Next, for accordingly, the court is inclined to close this writ petition, as because the petitioner has an alternative remedy to obtain a copy of the charge sheet and postmortem report. And insofar as the MVI report is concerned, it would the concerned tribunal can always be moved to have the report called for from the competent authority. Full stop. Accordingly, the court finds no reason to keep this matter pending, and according to this, petition signs closed. You can get a copy always. Charge sheet can't be given in a RTI. Oh, bless you.
28.
Yes, Mr. Parvez.
The petitioner before the lordship is a partnership firm represented by its authorized signatory. And the respondent number 1 and 2 are companies. These are other company. They deal in production and sale of coal throughout India. During their course of business, they came up with a notification dated 25/11/22 for spot e-auction of different grade of coal.
Once you say that, Mr. Talukdar,
Right.
you see, this is a firm Mrs. Maihar Developers,
Yes,
correct?
yes.
If it's a repetition in Article 220, you have to show that a firm can maintain a repetition.
Lordship, I have stated in second paragraph. also.
If maybe giving some time to find a count.
No, just a moment.
Lordship, I have stated in paragraph 2,
Paragraph 2.
yes, that the respondent number 1 is a
Well, I'll
complaint.
tell you something.
Well.
I forgot the case, if my memory serves me right. There's a constitution bench judgment of barium chemicals,
BBG.
barium chemicals limited. Where it has been held that company will not have a what do you call constitutional rights except for Article 19 or 21. Those rights are not available.
But I am not a complaint, petitioner is not a complaint.
Petition is a firm,
Firm.
but firm can a repetition be maintainable on the basis by a firm.
But when the respondents are come within Article 12, you can always, the report can always adjust.
No, you'll have to impeach somebody, some person as one of the petitioners. That is the point I'm trying to make.
Madam,
Somebody by living person has to be made the party. Representation capacity will not do. So somebody will have to be included as respondent number 2.
respondent number 2, general
Yes.
manager.
You know, only a citizen would have
Lordship, we have.
certain rights.
Oh, second petitioner, I'm sorry, my lord.
No, I'll just show you that.
I have said that.
It's
so
okay.
and so
I'm
develop-
just trying to find out. Just give me 2 minutes. This is the observation. Just
Yes.
Para 38.
No, no, sorry.
I'll issue a notice, don't worry, I'll not dismiss it for that term,
My lord,
but
lordship, I'll give the sentence.
you'll have to, at barium chemicals,
My lord.
it's a constitution bench judgment. You are asking for a refund.
My lord.
You are
Yes.
asking for a refund in this case.
Refund, and also they should not close the account and pay the government levies, because it is, they have calculated it on 4,000 metric ton, whereas I have lifted only 2,835 metric ton.
Well, what is the effect of that? If they don't close it, what happens?
Then they'll pay the levies, government levies, they'll deposit in the calculating at the rate of 4,000 metric ton. Whereas I have lifted only 2,835.
Okay, till the next day, don't take action against them.
No, right now, no. Let me first give a counter because the facts
It's okay,
are-
but there must be some clarity. If you do it, it can't be undone thereafter.
Yes. That
So
cannot be.
till next date, you don't take what you call look at the prayer, Mr. Ahmed, intermediate, page 16. Not to close the contract. Is it okay?
Because the contract is over after.
No, I'm trying to understand the coal India's perspective.
Contract advice is over as far as that deal is concerned.
Okay,
It is against one particular e-auction policy.
okay,
The term was for the particular amount of quantity of coal,
yes,
and that was over.
yes.
As far as the money that he's claiming, I have no objection. We won't trouble him at this stage.
Okay, no, so what is it, the correct language? What is the correct language to be used?
I am saying.
Not to
close.
finalize the account? Not to finalize the account? Correct.
That can be done.
Mr. B.J. Talukdar, and senior counsel, assisted by Mr. E. Talukdar, counsel for the petitioner. And Mr. M.Z. Ahmed, and the senior counsel, assisted by Mr. A. Dattar, and the counsel for the respondents. Next, para. Okay,
have-
and Mr. K. Goel, and CEC appearing for respondent number 4. The case projected by the petitioners is that they had deposited the entire purchase price of 4,000 metric ton coal.
No, 4,000.
4,000 metric ton, that's what I'm saying. Coal to the in the office of the area sales manager, Northeastern Coalfields, Margarita, and could lift only a quantity of
2,835.
2835 metric ton. Where is this annexure 6? Where is that?
Annex 6 is
Page?
32, page 30.
What is the wrong here?
Is my lord, they say that
3970.
It says, my lordship will find at the right hand column. Net weight is 3970.
Yes.
This is the allowable weight of one particular rake.
Carrying capacity.
You purchase only one rake.
One rake.
It is by referring to the bill. Public invoice dated
14,
20,
14.3.
sorry, 7/3/2023. No,
No, 14.3.
14/3.
2023.
2023, it is submitted that the bill quantity is 3970.00 metric ton. And therefore, the petitioner claims that according to this, by filing this rate petition on Article 226 of the Constitution of India, the petitioner has paid for setting aside the said invoice with a direction to the respondent authorities to rectify the mistake in the billing and refund the amount refund the amount of money for the unlifted coal. Next, for the issue notice of motion returnable on. When Mr. Ahmed? How much time?
3
Returnable in 3 weeks. Requisite extra copies of the registration be served on the Ahmed. Standing also for the respondent numbers 1, 2, and 3, and the done CGC in course of the day. Next para. As an interim measure and take the next returnable date, it is provided that the respondent numbers 1, 2, and 3 shall not finalize the accounts of the petitioner. List after 3 weeks.
14 or 16.
Achha. Yeah, I'll add that, otherwise it will be fatal for you. The senior counsel for the petitioner is leave to implead the appropriate parties or the co-petitioner in this rate petition.
In fact, lordship, I'll do that, but farm is a farm. Farm is not a legal entity, so
I'll tell you, then also you suffer a disadvantage. I'll tell you why. You see, there are two things. Number one, a firm may be a firm of partners, correct? The second is that a man carries out business in the name of a firm, say like a chartered accountant,
Right.
X and company, chartered accountant.
Right.
So he does the work as a chartered accountant, is a proprietorship firm. So even in a proprietorship firm, the party to sue can be a firm, but the owner has to be implemented. Otherwise, a firm is not a. You see, the constitutional rights are not available.
there is not a-
Except for Article 21, I don't think we'll be able to establish a case where rights of a firm vis-a-vis Part 3 of the Constitution can be enforced. That is first one. Second is that if it is a partnership firm, then you see the requirement of 2 and 3 of this order would be that the names and other things are to be disclosed. Because
I
here
can
you are
disclose.
here you are saying that it is represented by an authorized signatory. That is not enough. It doesn't constitute a firm. It doesn't constitute a firm. Authorized signatory, because then again the third thing is if you say it's a authorized signatory, then the third thing which is required is to produce a what you call your power of attorney.
As part of
Right.
it should be resolution should be there also.
No, if it is a firm, there is no resolution. If it is a company, then it is required.
As per their environments, they have two lots. It's a
No, I
company.
have seen that. That's why I'm saying. That's what I'm saying. You see, you are absolutely right. When it comes to company, then resolution is required. Then there are Supreme Court judgments on that point. So you, therefore, you suffer a disadvantage.
Lordship, I will be.
I have permitted you, you do it. You file, quickly application.
I'll file a separate application or can we prepare it right now?
You want to do it by hand? Acha, we are here with you. Mr. B.J. Thakur, Senior Counsel for the petitioner. Praise for his granted liberty to approach the Registrar Judicial and impede the concerned the person representing the firm to be carried as petition number 2. Then you also say pending the implement of the petition number 2, issue notice of motion like that. Do it by tomorrow. Because we don't take so much note of that. Every day we are issuing a notice of motion, but this is a constitution bench judgment. At times it can be very fatal.
Can the date be fixed around mid?
14/6.
29.
Yes.
Wait, please, Lordship. Under petitioner before your Lordship, Malad is a registered contractor, Malad, under the city engineer, There, Malad, the executive officer, Malad, of Sathyavari, Malad, municipal board, Malad, had issued a tender, Malad, for construction of 8 numbers of road under that municipal board, Malad. And the tender, your Lordship will find at page 17. As being eligible, Malad, petitioner had offered his tender against all these 8 numbers of packages, Malad. And subsequently, Malad, on 2nd of February, Malad, the bid was open, Malad, and both the petitioners qualified in both technical and financial bid, Malad. His bids were expensive, Malad. And a comparative statement was prepared, Malad, on 2/2/2023, Malad, whereas Malad petitioner was alone, Malad. But subsequently, Malad, what happened,
I'm
Malad?
merely issuing a notice. This is something I'm not granting.
Malad, here, Malad, petitioner had Malad, for his friend, Malad, of course.
Pardon me?
RTI application, Malad.
Yes.
Malad, to obtain that certificate copy of the Malad comparative statement, Malad.
Yes.
Malad, instead of supplying that, Malad, in fact, Malad, the very of the.
No, if you are not getting information from RTI, go to the appellate authority.
Malad, your
For that, we can't entertain a writ petition.
Is very correct. But what happened, Malad? In this meantime, Malad, since the agreement has already been executed, Malad, they are.
We can't
what
stop
is-
that. The third
What is
party,
already in progress, Malad?
rights have been created. We are not staying it.
Malad, otherwise, Malad, it's suffer some activities, Malad.
No,
At least, Malad, the status quo, Malad.
you file a civil suit. You see, you are asking for a Mr. Hawk for a status quo. What would status quo mean? According to you, please tell us.
Malad,
According to you, if somebody has been, there is an agreement, what does the status quo mean according to you?
Malad, I mean by this matter, is what, since the work has already been started, Malad, there should be stop, Malad.
Can the status quo mean that?
It should be as it is, Malad, as on today, Malad.
Status quo would mean that if somebody is working, he'll continue to work.
Malad, there, Malad, intentionally.
You see, the construction amount is 21 lakh. Are you prepared to deposit that amount in the court as security? 21,63,836 is the contract amount. There will be price escalation, there may be something, so many things. Are you prepared to provide this money as security?
Malad, if Lordship permits, Malad, to deposit security, Malad, right? Deposit, Malad.
Okay, then tomorrow we'll take it up as motion. You take instructions tomorrow. If you are prepared to give security.
Malad, by tomorrow, Malad.
You tell us tomorrow, if you say, yes, we'll pass an order. We'll take your security, but tell us whether you are ready to give that security.
By tomorrow. Okay, instruction.
Tomorrow you will get instructions. We'll give you 2 days time to make that payment. Within this week, your security must come, is go to this municipal board. Tomorrow, list answer in the motion column.
Party to,
The bid amount must be offered by you as security. Hmm.
Apply.
Thirty-two. Petitioner is not there, my lord. They are against the eviction drive. I have instructions to that effect.
Yeah, but in the absence, we can't,
Yes, madam.
we should not take it.
My lord.
Okay, for just the matters to adjourn, okay, list on. It's an eviction matter, list on. Look at Wednesday, 24th.
My lord is fixing some date.
So eviction matter, we can't postpone
My
it
lord.
very long.
Okay.
63, 63.
Yes, we have filed the demarcation report. Government, Mrs. Sharma. We are required to file a demarcation report.
I've received instructions.
That the instructions are already recorded here. We
Yes,
have to
madam.
file
In
it.
fact, the affidavit is ready. We'd asked them to come, but they've not come to swear it.
We send police to them.
I will, madam.
Yes. We send police to them. You said yes.
No, my. I didn't catch it. madam.
You're not the aggrieved now. Your work is stopped.
Yes, Lordship, the work is stopped. But
Okay.
they were supposed to produce the demarcation report, Lordship.
Okay, both sides are duly represented.
The road, the drain was demarcated earlier. Nevertheless, I'll file the affidavit, but I'll get the
Mhm.
officer. File the affidavit.
No, then you are outdated. I have better information than you. What you call, the earlier demarcation was wrong. That you have admitted. But don't worry, this I have read. You have admitted that the earlier demarcation was wrong. So that is why we are asking you
Yes,
to
ma'am.
file an affidavit. And that is why I said, should we send police to them to bring them to you?
Lordship grants me a few days' time, I'll
Okay,
get it done.
both sides are duly represented. Is S. Sharma and a government advocate. Case for him is granted 2 further weeks' time to file affidavit in terms of order dated 8/5/2023. I will give it fixed date after 2 weeks. List on 7.
96,
96.
No.
Deeply obliged.
64,
Yes, Mr. Das.
These petitioners, they have license from the mineral department, mines and mineral department. And they buy limes from the limestone from the Meghalaya and they process it here and they sell. This is your lordship will find page 36 with the dealer's rules.
And now the government has said, the forest department is saying that you cannot crush limestone. That power they do. I'm going to show that. On the page 36, your lordship, can you see? This is the Assam Mineral Regulations and Dealers Rules 2020, page 36. Your lordship,
Page,
36.
yes.
This is the power of the Mines and Mineral Department. May I just read this? In exercise of the power conferred under section so and so of the Mines and Minerals Act, the Governor of Assam is hereby pleased to make the following rules to regulate the possession, storage, trading, and transportations of minerals, and to check evasion of royalty or so and so fees, stopping of illegal mining and transportations in the state of Assam. These rules may be called Assam Minerals Regulation Dealers Rules. The rules shall be applicable in all mineral dealers, to all mineral dealers and all industries, factories connected with the sale, purchase, transportation, processing, and consumptions of minerals for commercial purpose in the state of Assam. Now, the competent authority rule 2B, my lord, competent authority means gazetted officer not below the rank of deputy director of so and so. Now, mineral is there at page 37K, my lord. Page 37, mineral means minerals of all types mentioned in first and second schedule of Mines and Minerals Act 1957. If your lordship goes to that schedule, your lordship will find limestones.
Okay,
May I take your lordship to that schedule, man? It is there.
it's okay, we'll
It is
accept
there,
that, sir. Huh.
Now that on the basis of these rules, this page 43, this dealer license they have. I'll just take your lordship. This is the dealer license in respect of the petitioners from page 42 to 48. And page 49 is the renewal applications given. And page 54, my lord, consent to operate up to 26 from the Pollution Control Board. Page 54. Now, one aspect of the matter I would just like to point out before your lordship, page 65. Page 65.
Yes,
Yes, page 65, this is the gazette notification dated 3rd March 22.
yes.
Second, my lord, in the principal rules in the list of minor minerals, serial number 10 shall be omitted. This 10 is my lord limestone.
Serial 10 is limestone.
Limestone. And next is, my lord, in the principal rules in schedule 10, serial 7, and the entries there too relating thereto shall be omitted. That is also limestone.
So then who will be the authority?
Authority is, my lord, Mines and Mineral. So under them, my lord, they got the license and the Pollution Control Board. On the basis of that, my lord, they are.
No, if limestone is omitted,
That
then
is
it-
for in respect of the forest. My lord, this rule, dealerships rules, if your lordship goes. Minor mineral concession rules, under which the forest department exercise their power. I'll come to that, my lord, your lordship will know about it. Now this, I'll just take your lordship to again the dealership license, page 43. Once again, my lord.
yes, it contains processing.
Yes, it contains processing. That's what I wanted to show. Now, your lordship will kindly see that schedules I have shown that March 22. Now the impugn order, your lordship will kindly see. Well, some other facts are there. I'm not going for the purpose of my lord, since it is the motions. Page 66, your lordship will kindly see. This is the impugn order. Impugn order says you cannot crush.
56,
66.
66.
Whereas, my lord. Whereas as per 10 schedule of the Assam Minor Minerals Rule 2013, 10 schedule is gone, my lord. That limestone is gone. I have taken your lordship through that amendment. Amendment says, my lord, limestone is withdrawn. Certain minor minerals, including limestones of any grade, are listed for industrial purpose use, and of which Director of Geology and Mining is the competent authority as per Rule 3, 2013 rules. And whereas Schedule Y incorporates minor minerals, including stones for use other than industries under the control of the principal chief conservator. That Schedule Y, my lord, that limestone is not there. And whereas as per the stones crusher, this is a establishment rules and regulations, the Department of Forest is the regulatory authority for establishment, procurement and movement of stones, raw materials and products, which is clearly a Schedule Y material. Schedule Y material is also, that is not there, and this is this rule is regarding stone crusher. My lord, I can have a crusher, I can crush, my lord, coal, I can crush, my lord, limestone, but for the purpose of stone, this regulation has to be followed. Now, next, my lord, whereas the Honorable High Court in PIL white number so and so has clearly held that the limestone is included in Act Schedule. That is a big judgment, my lord, which did not take into consideration this amendment. I'll come to that judgment also, over which the Department of Forest has no jurisdiction, and accordingly, set aside an order dated so and so issued by the Chief Conservator of Forest, nodal officer, by which permission was granted for crushing of low-grade limestones in the stone crusher units. And whereas it has been reported that huge quantities of limestones from Meghalaya are entering into the state of Assam and are being used for construction activities instead of stones, for which the state of Assam is not only losing huge royalty, but has also led to inferior quality of constructions, wherein also funds are being wasted. It is also seen that the stone is being sought to be replaced by limestones, which is not authorized construction material. Now, they are nobody to say that the limestone is good or bad. I'll come to that, my lord, what they have said earlier. But if somebody says it has to be by the Mines and Minerals. This is a recognized, my lord, items which is used by, we purchase, we grind it, we sell mostly to Nagaland and Tripura. And some contractors, they also buy from us. So, and they use us for the government construction purpose. For that purpose, they will have to catch hold of the contractor saying that you don't use these limestones. But for the purpose of money, since I have got a dealership, I have a right to process it and sell it outside. They are entitled to get GST, royalty, etc. Everything we have paid. Now, last year, Lordship, can you see? In view of the above, the undersigned being the competent authority under the Assam Minerals Rules 2013. Under these rules, my lord, they have no authority to do anything regarding the limestones because of that amendment 2022. And also being authorized under the Assam Forest Regulation. I'll come to your lordship. Do hereby direct that no stone crusher unit throughout the state of Assam shall henceforth crush any material, including limestones other than stone, in the crusher units. In the event if it is found that any crusher unit is crushing limestones for any grade, the respective license of the current crusher unit shall be forthwith cancelled, and appropriate final action shall be initiated against the such crushment in accordance with law. Further directed that all concerned DFOs shall take action against stone chips of any schedules if transported without authorized challans, and shall also take action if limestones of any grade and or challans in the name of limestones are being used for any kind of construction activity, same being Schedule X. It is not Schedule X items, I have shown. Now, a person to this, my lord, they have issued this letter. Page 69. They address a letter to the Northeast Frontier Railway. It says, my lord, with reference to the above, I would like to inform you that as per Principal Chief Secretary Forest Department's letter number so and so, the limestones chips cannot be allowed for the time being, which are being used for any kind of constructions activities, etc. Now, your lordship will kindly see few months back what they have done. Page 99. Page 99. In one stroke of pen, my lord, they sought to, my lord, stop these petitioners from doing any business of limestones, for which they got the dealership from the Mines and Mineral Department. Page 99, your lordship will kindly see. This is a letter dated 4/10/21. It says, my lord, as per geology and mining communication, limestone having less than 40% calcium oxide can be used as building and road metal after crushing. This was their, my lord, letter. Therefore, it can be crushed in crushers for use in building, road metal, provided it enters in the crusher units on the transit permit challan of stone, not limestone, because after crushing, it is transported from crusher by the transit challan issued by the forest department, and forest department can issue transit challan only in respect of Y schedule matter, not for crushed limestone, which comes under schedule 10. So this letter was challenged by some persons, my lord. Ultimately, my lord, your lordship will kindly see that judgment. That is at page 112. And the relevant is at page 114.
Yes.
114. This is the letter I have shown, my lord, your lordship has read that letter. They have said that kasha, we can, that limestone can be used and all. This is the letter of the forest department, at page 99. Has your lordship seen, my lord? 99 I have read. Now page 114, that is the PIL's order. Somebody has challenged that you do not have right to say something about the limestone. That pressure, that the PIL came, and the PIL, during the PIL, it says paragraph 5. May I read, my lord? During the course of arguments, learned counsel for the petitioner has submitted that the chief conservator of forest did not have any jurisdictions or authority under the law either to permit use of limestones in crusher units or to issue the order dated 21, since limestone is included under schedule 10. My lord, they did not take into consideration that amendment, which is in the year 22. Schedule 10, it has been removed from schedule 10 of the Assam Mineral Mines and Mineral Concession Rules 13. According to the petitioner, it is the Director of Geology and Mining which would be competent to pass such order if at all deemed necessary. This is what is the correct position, my lord. This is if something that you cannot use limestone, it has to come from the mineral department, not from the forest department. Forest department doesn't have any power. But they are putting their, my lord, nose everywhere. P.N. Goswami, learned additional counsel, additional advocate general appearing for the official respondent, has submitted in his individual fairness that the impugn order is without jurisdiction. So whereby, my lord, the impugn order, they have shown, they have said, my lord, the limestone can be used for chips and for building materials. The learned additional advocate general has further submitted that crushing of limestones by the crusher units for use outside the state was impermissible under the law. From where he has said, I don't know. Having heard the submissions, learned counsel for both the parties and other, after going through the provisions of Rule 2013, we are of the unhesitant opinion that as per Rule 3A of the Rules 2013, it is the Director of Geology and Mining who alone is competent to deal with minor minerals for industrial and specific uses as specified in Schedule 10, which include limestone. Therefore, the impugn order that is issued by the Chief Conservator of Forest is evidently without jurisdiction. Further, in view of the stand taken by the Learned Departmental Council to the effect that the limestone is being illegally used by the stone crusher units of Assam, we do not find any justifiable ground to decline relief to the petitioner in this suit. So it says, my lord, the letter which was written by the Forest Department allowing crushing of the my lord, limestone, that is all. My lord, how they, my lord, interfere with the business of these limestones? They cannot create job, that is all right, my lord, but they cannot stop, my lord, this business of limestones which the petitioners have undertaken with due permission from the mines and mineral. They have license and all. Your lordship will kindly see this letter to page 70, my lord. This letter, my lord, it says, my lord, it is addressed to Divisional Forest Officer, Jointa Hills Territorial Division, Joy, and it is written by the DFO Karimganj Division. Kindly requested you to ensure that the vehicles carrying stone chips of limestones are not allowed to enter the jurisdiction of Karimganj Division. Last sentence, your lordship. After inquiring all these things, and the reply they have given is that reply will do the needful, my lord. It's a short reply is at page 72. Page 70,
Page,
72.
yes,
With reference to this, this is the reply given by the DFO Jointa Hills. Cited above, the office of the undersigned would like to inform you, your good office, that so and so have procured the limestones from the mining lease holder granted under this division, and he is regularly procuring the limestones with valid challan from the registered mining leaseholder. The forest royalty so and so, GST so and BMF has been paid by the leaseholder. The sample copy of the end used certificate is enclosed herewith for ready reference. So they are not subjected themselves to the jurisdictions of Assam. They have gone beyond the jurisdictions of Assam in saying how they are procuring. Lord, one aspect of the matter I would like to point out before your lordship goes to page 36, your lordship. This rules, my lord, Assam mineral regulations and dealers rules have been framed in exercise of the power under section 23C1 and 2 of the Mines and Mineral Act 1957. If your lordship goes to that, my lord, your lordship will find fourth schedule provides limestones, and on the basis of this, my lord, this regulation will be made. So therefore, my submission would be, my lord, on the face of the, my lord, impugn order and the order which has been addressed to the area manager, my lord, railway at page 69 is without any jurisdiction and without any authority of law. So therefore, and it has, my lord, impacted petitioners' business, my lord, which they have been carrying on the basis of the license, dealership license, and the provided by the Mines and Mineral Department. So therefore, I pray my lordship will admit this petition, stay the impugn order, also page 69, so that the petitioners can, I will take undertaking whatever undertaking is required to be done. But it is the Mines and Mineral Department who has the power and not the authority.
yes.
My lord, up to a extent, my lord, Learned Singh is very correct. Limestone has been taken away from the AMC rules. Keeping aside that rule for time being, my lord, we have another statute, my lord. There's a statute called Assam Forest Regulations, my lord. And that apart, my lord will come to amendment number 3, page 11 of the petition.
Page 11.
Page 11, paragraph 3.
Yes,
The petitioners respectfully state that they have their own crushing units in different districts of Assam and all have been dealing in the same kind of business. So, my lord, these crushing units are regulated, controlled, and established by on the strength of a notification of the Forest Department. Our case is very clear that if this stone crusher is established within our rule, since we don't control limestone, you can also crush limestone out there. That is a case, my lord. And that apart, my lord, if my lord sees, I've handed over, my lord, there's the regulations, my lord. This is, my lord, notification of 2003. It is a guideline, my lord, which at presently, my lord, which governs the field. And somebody within the state of Assam, if he wishes to establish or regulate a stone crusher, he must apply within its ambit. And apart from that, you have, my lord, taken up this Assam Forest Regulations. Assam Forest Regulations, my lord, will see definitions part, regulation number 3, sub 4, and my lord, within sub 4, there is another Roman 4. It starts from what is a forest produce. Forest produce includes, my lord, I'm skipping every part. I'm coming to Roman 4 directly. Peat, surface soil, rock, and minerals, including limestone, laterite, mineral oils, and all products of mines and quarries. Petitioners are very correct, my lord, that they have these licenses from Mines and Minerals Department. Well, they can go and they can have their business. We have no issues with that. Our only contention is that since it is a this crusher units are established under the forest department. In our crusher units established, regulated by our forest department, you cannot crush limestone. Since it doesn't come within our domain. And also, my lord, in the regulations number 40, my lord, power to make rules to regulate transit of forest produce.
Is that Assam minor minerals concession rules?
I can hand over. But that has been, my lord, amended and limestone has been taken away, my lord. Limestone is not out there anymore, my lord. That up to that extent, learned senior counsel is very correct. But my lord, this statute, which I lordship, it is before lordship, Assam Forest Regulations, my lord. It describes, it covers within its ambit, my lord, this limestone.
Just wait. Where is the schedule 10?
Schedule X, my lord.
X, where is that?
X is, my lord, will find at the end part of the book, my lord, if I'm very,
End.
if I'm correct, my lord.
End part.
End part, my lord. Lordship has got it. There are
There's-
two schedules, Schedule X and Schedule Y.
Schedule X.
Schedule X, my lord. Schedule X, my lord, will, for Schedule X, my lord, the competent authority is the Director of Geology and Mining, my lord. And Schedule Y is the other subject wherein my lord, Forest Department has jurisdiction. I agree to the proposition that we don't have any jurisdiction over limestone. Our only contention is that since we regulate the stone crusher, we establish the stone crusher, you cannot, one cannot crush limestone in that crusher, my lord.
No, then you should stop issuing license for that.
No, because
stone
it is for
crusher.
stones, my lord. It is for stones. Stones are treated differently, my lord. Limestones and stones are.
No,
two
no, I
different
understand. You
categories,
see,
my lord.
I understand. But if certain things is not within your jurisdiction,
My lord,
why you have a control over the stone crusher then?
we have a control of stone crusher because my lord come to Schedule Y. Schedule Y, my lord, item number 4, boulder. When used in construction of roads and buildings and other than mines in large scale for export or for construction of dams, dikes and bridges. Boulders is my lord stone. Also, my lord, stone is also for when used for household utensils,
No, you see, let me understand the scheme.
my lord.
Crusher, if somebody uses for an item which is not a forest produce, then also are they required to have a license from you for
Yes,
operating
my
a
lord,
stone
because
crusher?
stone crushers are, this is my lord stone
No,
crusher.
how you get the jurisdiction?
My lord, we get this jurisdiction from my lord. Since my lord, I have shown that stone is there, boulder is there, a Schedule
No,
Y.
that is boulder. Boulder is not limestone.
No, my lord, we are saying you crush boulder, you crush stone. But in a crusher unit which is established by our consent, we regulate it. You don't crush a material which is not within our jurisdiction. That is our point. If limestone is not
No,
within our jurisdiction,
have you given that letter to anyone?
which my lord?
The statement which you are making,
Yes,
is that a part of any communication to the petitioners? No.
well, that is there, my lord. That in Impunora itself says that, my lord. Impunora itself says that, my lord.
So, Mr. Das, we record that statement. That's the end of the matter.
And that apart, my lord, I have a
That-
citation if my lord takes up.
Stone will not
My
crush stone,
lord is very,
No.
yes,
He's saying that if you are operating a query on the
Not
basis of a
query,
forest
I'm-
license.
I'm not.
a stone crusher, not query, my lord, stone crusher.
I buy, my
Stone
lord,
crusher.
I buy limestone, my lord.
No. Mr. Gogoi is saying that once you are operating that stone crusher
Yes.
on the basis of
Not
their
stone
license.
crusher, it's a crusher.
So
If
whatever
somebody
be,
crush
whatever,
for a stone, it is
no,
stone
whatever
crusher.
be,
Yes.
but his contention is very simple.
Yes.
That if a crusher is installed at his permission, you don't crush anything else there.
With his permission, we are doing, we only crush many limestone. They have no, this is not their family property, that crusher
crusher, I can also buy and keep it in my thing for crushing my table chairs. I can do it, but I can, some crusher machines.
So
are
do you
used
have a
for-
license from them? No.
No, it is not required. My license is for processing also limestones.
No, crushing license, you have one.
No, crushing license, my lord, that pollution control board I have,
Where is that?
that says 54.
54.
Yes, this is what came up before, my lord, the other code one day. Easy,
No, just a
your
moment. Let me understand.
54, my lord. For the year 2026 to 2027.
Mr. Gogoi, where is the crushing unit at
I
your
can
license?
buy a
My
crushing
lord, that
unit for
I can
anybody.
bring. What had happened, my lord, there is another set of writ petitions, my lord. It is 6603 of 2019. Wherein, my lord, one of the petitioners here in Ashish Tusniyal, his motive goes petition number 2. He is also questioning our competence that Assam Department of, because he was caught crushing limestone, my lord, invoking the rules, my lord, we had sealed his everything. Now he had brought a contention that Department of Forest Assam does not have the legislative my lord, competency to regulate stone crushers. That is a question still lingering on my. And that apart, my lord, and I can bring the licenses because right to consent, consent to these licenses are given by us, my lord. Right? I can produce it tomorrow itself, my lord. These licenses.
We'll take it up day after tomorrow then.
Yes, my lord. Yes,
You produce that.
yes, I'll produce, my lord.
He says that the license is under them. Let him produce it day after
But,
tomorrow.
according to me, my lord, license is not required. Once I buy a
No, that is okay.
Yes.
That is okay, but he says that if it's a license issued
They
by
will
him,
cancel the license, my lord. For the purpose of crushing stones, I may be required a thing. If they have bought it under, for whatever reasons, I do not know, I'll also take instruction from the client.
day after tomorrow, we'll assume.
My lord, I can bring the licenses of each and everybody, my lord.
Okay. Mr. Biridas, Learning Senior Counsel, as well as Mr. Instructed by Mrs. R. Deka, Counsel for the petitioners. Next para. Mr. D. Gogoi, and Standing Counsel for the Forest Department. Phase 4 is granted time to produce the license for operating a crusher issued by the forest authorities in respect of the petitioners.
Right.
Next para, list in the motion column 1, 24,
Right.
5, 2023.
Always.
This I am returning. You take back
Right.
your books.
May I please,
Yes,
if the present petition has been filed, challenging the impugned order passed by the respondent number 2, demanding service tax on the exempted services provided by the petitioner number 1. We are challenging the impugned order on the ground of jurisdiction and violation of principles of natural justice.
where is the notification that the service which you are offering is exempted?
Lordship, that is at page number 57, annex 7.
Page 57.
Serial number 2.
Yes,
Serial number 2, healthcare services by a clinical establishment, an authorized medical practitioner or paramedics. Lordship, the petitioner number 1 has been operating diagnosis.
is hospital equivalent to clinical establishment?
Yes, Lordship. Lordship, they were operating a diagnostic center in Guwahati. This notice
Okay.
pertains to the diagnostic center. And Lordship may kindly come to page 61. Clinical establishment has been defined there.
Where?
It is at clause 2J, page number 61,
61.
in the bottom.
Okay.
2J. Clinical establishment, this has been defined, and diagnostic center is categorically covered out there. Clinical establishment means a hospital, nursing home, clinic, sanatorium, or any other institution
by whatever name called, that offers services or facilities requiring diagnosis or treatment or care or illness, injury, deformity, abnormality, or pregnancy in any recognized systems of medicines in India, or a place establishment.
Yes, then we issue notice then.
Lordship, I have preliminary objection, Lordship.
Yes.
Because there is a statutory remedies available to the petitioner under section 86 of the Finance Act 1994. And on last occasion, I have produced one judgment of the Philippine bench, Lordship. Similar issue was involved there. That is, order is available in the record, Lordship. It appeal 188 to 2020.
Yes.
In that case, also Lordship for single, learned single judge dismiss the writ petition. Here also, Lordship, the petitioner made contention before the dishonorable court. That the service against which the service tax is levied, they are exempted.
No, but Mr. Kyal,
Lordship.
you see, if something by statute is excluded,
Lordship,
you issue a notice and then subject the citizen to the appeal and all. You see, let us take an example. It's an example. It may be inappropriate, but an example. You see, you demand a tax liability of say 1 crore rupees on someone for an exempted service.
Lordship.
Correct. Then I don't know about your act, but then you say for filing an appeal, you pay 40%. I'm just telling you, it's an example. It may be inappropriate. So therefore, a citizen who is exempted by a government notification will go in appeal, pay 40 lakh rupees, and then adjudicate its appeal.
Lordship, that is appealed by the Honorable Supreme Court. Lordship.
Where is that?
That judgment, Lordship, the name is with me. That is, that was division by our High Court in WPC 7672 of 2019. Relying on judgment of Honorable Supreme Court that paid deposit is mandatory. Paid deposit is mandatory.
No, does it say that even for an exempted service where the
Here, Lordship, if Lordship consider on merit, Lordship, may please come to page 159. Paragraph 4.4,
page 59.
159.
159. Yes.
4.4. I find that the notice in their written reply dated 2/11/2020 and also during the course of the person hearing held on 21/11/22 has basically contended that they are exempted from payment of service tax as they are clinical establishment engaged in healthcare services. They also submitted copies of their audited financial statement for the financial year 16-17 and ST3 return for the period from 2016 to September 2016 and October 2016 to March 2017, along with their written reply. I find that in terms of clause 2(1) of the notification, number 25 of 2012 ST, stated here that the healthcare services by clinical establishment is exempted from service. The said clause 2 read as follows: healthcare services by clinical establishment on authorized medical practitioner or medics. Again, clinical establishment and health services, care services have been defined under clause J and T of para 2 of the said notification. Clinical establishment means a hospital, nursing home, clinic, sanitarium, or any other institution by whatever name called the offered services or facilities regarding diagnosis and treatment or care of illness, injury, deformity, abnormality, or pregnancy in any recognized system of medicines in India, or place established as a dependent entity as a part of establishment or carry out diagnostics and so. Then there is a definition of healthcare and services. Then 4.6, I find that though the notice has claimed that they are provided healthcare services as clinical establishment, they have neither explained how they fulfill the above conditions, nor they have submitted any documentary evidence to substantiate their above claim. In view of the above, I do not find their above contention acceptable. I find that the so-called notice was alleged that the notice did not file ST3 returns, but it is fine from the copies of ST3 returns submitted by the notice that they filed the ST returns for the period. In the said ST return, they declared values pertaining to services at service tax liability on reverse charge basis only. Their contention has been considered by the executive authority. Then Lordship, page 154, close 2.
Just a moment. One
154.
150, this is the, this order with the authority.
In order, Lordship.
Yes,
Close to any person deemed himself aggrieved by this order may appeal against
just a moment. Which page did you show me earlier?
154.
No,
Regarding the exemption.
yes, regarding exemption,
That was annexure 7, but it is at page 57.
57. Yes, Mr. Muskan,
Lordship. Page 154,
yes,
close 2. Below, Lordship.
yes,
Any person deemed himself aggrieved by this order may appeal against the order to the Customs, Excise and Service Tax Appellate Tribunal in form ST5 within 3 months from the date of receipt of order sought to be appealed against. The appeal to the Appellate Tribunal shall be filed in quadrilateral on payment of 7.5% of the duty demanded. Then and section 86.
yes,
And section 86 of the Finance Act 1994, which stipulates for filing a statutory appeal. Appeal to the appellate tribunal. I'm reading your see. Any SEC aggrieved by the order passed by a commissioner of Central Excise under section 73 or 83A or any order passed by a commissioner of the Central Excise Appeals under section 85 may appeal to the appellate tribunal against such order within 3 months from the date of receipt of this order.
yeah, Mr. S.K. Sharma. Yes, Mr. Sharma,
Lordship, this impugned order was passed without any jurisdiction, Lordship.
without,
Without jurisdiction, Lordship. This was actually barred by time. Lordship may kindly come to page number 24. If I can quickly read the provision under which this so-called notice was issued. Recovery of service tax not levied. Page number 24 of the writ petition. Section
no, you
7.
see, rightly or wrongly, if an order is passed, then you'll have to subject yourself to appeal.
Lordship, this, the provision requires that the show cause notice was to be issued within 30 months from the relevant date. This show cause notice was issued almost after 5 years. And Lordship, in the show cause notice, the allegation was different, the order comes in a different manner.
Where is that? Page 24 you are showing.
Yeah, page 24, section 73. Recovery of service tax not paid or not levied or paid, or short levied or short paid or erroneously refunded. Where any service tax has not been levied or paid, or has been short levied or short paid, or erroneously refunded, the Central Excise Officer may within 30 months from the relevant date serve notice on the person chargeable with service tax, which has not been levied or paid, or which has been short levied or short paid,
or the person to whom such tax refund has been erroneously made, requiring him to show cause why he should not pay the amount specified in the notice. So Lordship.
No,
the
but you
show-
see, the issue is that once you subjected yourself in that proceeding, you gave a reply. That was not challenged, and once this order of the
Lordship, it was
authorities
challenged,
passed.
Lordship, in the the service.
No, not that the notice itself, you see, once an adjudication is made, then perhaps the court would not have power to invoke Article 226, because then the statutory remedy availed must be, prescribed must be availed.
Lordship, the allegation in the notice was that the SSC has not filed their service tax returns.
No,
But
you
the-
see, whatever be the proceeding,
No,
any proceeding,
Lordship, we
in
have
any
submitted
proceeding,
a-
in any act,
No, we
you
have
take
submitted
example
our
of a-
request to the department. And then the department, while passing the order, they are passing the order on a different ground, Lordship.
No, it's okay. You see, you go by any proceeding, any law. Correct. You take Debt Recovery Tribunal, what you call that, Recovery and Bankruptcy Act. You take whatever act you think of, where in respect of original jurisdiction, there is a period of limitation prescribed. Let us take a suit, for example, or a criminal proceeding where under 468, the proceeding is time barred. And the court adjudicates it and passes an order on merit. Then what happens? The period of limitation cannot be a ground to challenge it under 227 or 226.
Lordship, the proceeding itself was illegal, Lordship. It was without any authority of law.
No, once the proceeding is over, then even if it is illegal, you see, why do
Lordship,
that?
what happens is that the show cause notice was issued on the ground that the service tax returns were not being filed. The service tax returns were filed and this was produced to the respondent number 2. That has been already acknowledged in the order also. But then the respondent number 2 takes a U-turn out there and passes the order on a different ground for invoking the extended period of limitation.
Where is the show cause notice?
Lordship, the show cause notice is that page 150, Annex 11,
Page 140.
140. Lordship, the date is important out here. The date is at page number 152. This is 22/10/2021. The show cause notice was issued for proposing to recover service tax pertaining to the year 2015-2016. And this was issued on 22nd October 2021, after almost 5 years. In 148.
Where is your reply?
Lordship, there was a personal hearing was granted.
It's okay. Where is your reply? The reply is at 153.
Page 153.
Regarding limitation, no whisper is there.
That's what I'm trying to read. No, is there?
Lordship,
You also say in page 143.
140, Lordship,
Page 143 is a part of your show cause
yes,
notice.
yes, Lordship.
You have also said that it is a 30 period within a 30 period.
Yes, Lordship, may come to page 148, paragraph
Page
70,
140.
148. It's a part of
Eight.
notice. 17, invocation of extended period of limitation under proviso to subsection 1 of section 73 of the Finance Act 1994. Whereas the said notice being a taxable service provider they were fully aware of the fact that the services provided by them were taxable in nature, and they were in, in an obligation to discharge their service liability properly. It is pertinent to mention here that the system of self-assessment is in vogue in respect of the service tax. Self-assessment schemes places greater onus on the SEC to conform to the higher standard of disclosure information in the statutory return. It appears that the foregoing paras, the said SEC willfully did not file their judicial ST3 return and did not discharge their liability to the government exchequer with the malevolent intention to evade payment of service tax. Various courts, including the apex court, have clearly laid down the principle of tax liability is a civil obligation, and therefore the intent to evade payment of tax cannot be established by peering into the mind of the taxpayer, but has to be established through regulation of tax behavior. In the scheme of the self-assessment, the department comes to know about the service standard and payment made only during the scrutiny of the statutory returns filed by the service provider. But in the present case, the said notice neither filed the return mentioning the amount collected from the rendering taxable service nor paid service tax. Therefore, it appears that the said notice deliberately suppressed the material facts from the department with intent to evade the payment of service tax, and therefore extended period of limitation of 5 years as embassies under proviso to section 1 of 73 of the Finance Act 1994 for demand and recovery of service tax paid by the said noticee along with the interest under section 35.
Something is wrong.
What's it?
Something is wrong.
What's it?
From the website of I have opened up this section 73 of the Finance Act 1994.
Yes, Lordship.
It does not have subsection 1.
It is, Lordship, there was amendment to that. Lordship. 73(1) is there. Lordship.
Show me that, because in this there is not
Not
opening.
not to make the register.
73 is value of taxable service accepting assessment.
Lordship, no, this is a period of limitation. Lordship. Finance Act 1994. Lordship.
94, that's what I have opened.
That's, I've given the book. Lord.
That is why this taxing schedules are too complicated.
Yes, Lordship, because
You read somewhere, then you go to Finance Act, then you come back to some other act, then again a notification. And there is no clarity to it.
Lordship, 73 subsection 1 actually provides that the show cause notice has to be issued within 30 minutes.
No, whatever, but
Like-
once primarily they are satisfied that it was within limitation, it's a assessment already done. Then we'll relegate you to the appellate authority. Because then would be hit by this Supreme Court order.
No, Lordship, exceptions are provided in cases like this. Lordship.
You show us. Because if the relevant issue is dealt with, then even if the erroneous decision is there,
It has been dealt in, the thing is that the allegation which was formed for invoking the extended period of limitation was on the ground of non-filing of service tax returns. When we have submitted the service tax return, then the respondent number 2 confirms the invocation of extended period on a different ground, saying that the taxable turnover was not matching.
no, whatever,
And
be,
to
but
that
once,
extent, it
once
was-
they take,
The
once they
opportunity of
take a
hearing was
decision,
not granted, Lordship.
once they take a issue and decides it,
Lordship, but the order that has been passed was without jurisdiction, Lordship. It was without any authority of law. They cannot pass an order after the limitation period has expired.
no, it's shown 5 years of limitation is there, it's within. it will be
5
within
years,
time.
Lordship, on the ground of fraud, collusion, willful misstatement, suppression.
No,
of
escaping assessment,
yes, and Lordship,
escaping assessment.
under the scheme
escaping
of the
assessment,
Finance Act,
Lordship.
Lordship, it is their duty.
Here,
it is a
here they have not
self-assessment.
escaped, Lordship. What they are saying.
Recovery of tax not levied, short paid or erroneously refunded.
Lordship may kindly come to page number 107. There's a circular out there.
para 6.1, that is at page number 110.
Page,
Page number 110. The circular is at page 107, annexure 9.
yes,
And this is a master circular clarifying procedural issues relating to service tax.
yes,
At para 6.1, that is at 110, the last line.
yes.
Persons who are not liable to pay service tax because of an exemption, including turnover-based exemption, are not required to file a statutory return. In view of this circular, the petitioner was not disclosing their exempted services in the service tax return, but they were very much registered also under service tax as a clinical establishment providing healthcare services. This is a circular issued by the Central Board of Excise and Customs.
Persons are not liable to pay service tax because of an exemption, including turnover, are not required to file ST3 return.
So, Lordship, the taxable turnover which was declared was on the basis of the circular which was there. They were also registered for providing input services under reverse service mechanism. They were liable to pay service tax. Those they have been paid, and they have been declaring in the service tax return. But in view of this circular, the exempted services were not declared in the service tax return, but those were very much declared in the income tax returns and everywhere. There's no question of a suppression out there. The amount which has been taxed is there in my income tax returns, and they have taken it from the income tax returns only. It's the same Department of Revenue.
What is this circular 20 June 2012? 20 June is this page 57.
Page 57, that is a notification, Lordship. Under that notification, the petitioner number 1 was exempted from payment of service tax. Serial number 2. And Lordship can see at page number 55. That is
Just some. What is the date of the show cause notice?
Date of show cause notice is page number 152, 22/10/2021. Lordship, at Annex 6, my registration certificate is also there. I'm registered as a clinical establishment providing healthcare services.
Interesting. Where?
That is page 55.
55.
55. Lordship. Lordship can say flexible services out there. Health services by a clinical establishment, health checkup, public diagnostics, etc. So I have been also registered by the service tax authorities as a clinical establishment providing healthcare services, which is clearly exempted under the notification.
Page 50, which entry?
Lordship, there are two entries out in taxable services. You can see it's the third entry which is there. Taxable services. It's available as taxable services.
Page
And
56.
below the types of services is also there. They're in serial number 3.
Page 56.
55. Lordship.
55. 55, serial number 3,
Yeah.
health services.
Health services by a clinical establishment, health checkup, diagnosis, etc. So I've also been registered by the service tax authorities as a clinical establishment providing healthcare services.
Okay.
So Lordship, there was no suppression out there. The allegation of suppression was totally wrong.
What is the Supreme Court judgment you are referring to?
Lordship, today I have not got the copy, Lordship, is. It is reflected in division bench judgment of this honorable court in WPC 7672 of 2019 laws. WPC number 7672 of 2019 laws.
That is the Supreme Court judgment.
This is our High Court division bench judgment in that.
High Court division bench, there is one readable 188.
No, that is another with regard to pre-deposit of filing appeal.
Achha.
Lordship, in 188 actually a
WPC.
Supreme Court judgment has been referred.
WPC 7672 of 2019 of our division bench of our High Court laws. In that judgment,
This is disposal of dated.
Lordship, date is and this.
Mr. Das, just check out the WPC 7672 of 2019.
Thank you.
Yes, Mr. Sharma. Actually, is it WA 188 you are referring to? Okay.
Date of judgment is 18/11/2019.
18/11/2019.
Lordship. In that judgment, Supreme Court judgment is referred in.
Okay.
Lordship, on the other day, learned friend was referring to a writ appeal, which was disposed of by this honorable division bench. That in that order, it was referring to a Supreme Court's order, and there it was stated that none of the exceptions carved out by the honorable Supreme Court are made out so as to entertain the challenge led to an appealable order in exercise of the extraordinary jurisdiction. Lordship, in our case, we are falling under those exceptions, Lordship.
Yeah, examine that because I have to rise. There's a meeting at 4:30. Okay, I'll examine and pass on this. We'll be getting it uploaded tomorrow. In any other matter which requires urgent listing, please give it to the
Yes,
courtmaster.
Lordship, I'm begging for liberty, Your Lordship. Lordship, there's item number 60. Lordship, we have filed an IA for a direction, Lordship. My factory is closed, Your Lordship. And the the government authorities also accepted that the land.
You're telling one by one, he'll just.
On Wednesday, Lordship. On Wednesday, Lordship.
Okay.
Much obliged.
My lord, number 58 appeal is, my lord, it was a matter and was mentioned to be listed today. And my lord, it may kindly be taken up either on Wednesday or Friday.
Courtmaster, see that.
My lordship's item number 67
Courtmaster, see
For the
that
last
because I can't wait.
tomorrow.
Tomorrow is not possible.
Yesterday, on the last occasion, it was given on the production list, my lord. The basis of the court were taken up. Today it was fixed, my lord. It's extreme emergency for tomorrow, my lord. I'll even make a mention for upgradation tomorrow.
Tomorrow, I think there's some pattern matters which will listed.
It's only a touch and go issue, my lord. Otherwise, I got an unlisted matter mentioned aloud the other day. It could not be taken up. Today it could not be taken up.
But tomorrow there's hardly any chance. We'll fix it, but there's hardly any chance. Because
Status quo ante
tomorrow,
if need be. Status quo ante if need be, if I qualify, my lord. In the meantime, everything goes otherwise.
we'll have some pattern matters coming tomorrow.
My lord, item number 16 was part heard. May I pray for a short date?
My lord, item number 35.
The courtmaster will have to take it. I can't do anything. I have to attend a meeting.
Nine six eight video. अपना की तो फोन ले जाओ 44 29 of the अभी अपना बैठ करेंगे फायदे हेलो এটা আপনার আইটেম নাম্বার তো ওয়ার্কশপ বলবো এটা কি আচ্ছা কি হয়েছে একটু পার্টি তো না তাই পার্টি তো আমি পাঠাই দিন আপনার সেকশন করে লই যাও আজি তো নাযাব কালি যাই এইটো ঘটনা এনেকুৱা হেল্ল' আচ্ছা আচ্ছা বন্ধ কৰি লাইভ